Yes, good afternoon, all of you. I said good afternoon. You're awake or sleeping. Where we have stopped? I think we have done election commission. Yeah, any question from the last class? Any question? No question. Shall I ask the question then from the last class? Hmm? Yes, no, nothing. Okay, we'll start the judiciary part now. Page 27, if you are referring to notes. Yes, any question, any doubt from the last class? No? Hmm. Hmm. Yeah, obviously, that will not, see, that is far more difficult thing. 370 is a very, very big thing. 35A is just a part of 370, okay? So certainly, see, these are the temporary provisions, but removing 370 has a technical difficulties also, because it is being said that unless and until constitutional committee of the Jammu and Kashmir, who drafted the 370, their constitution, Jammu and Kashmir constitution, they should advise. Now that is not there. It is already been dissolved. So that's also the moot question, whether new constituent assembly can be created and whether the new constituent assembly can advise. So these are the difficulties. Okay, that's just one part of it, which is flowing from 370. Any other question? No. Okay. Yeah. Okay. Gender. Okay. Censored. Yes, you. Yes, please. Yes. Yes. Huh. That's a legal language. What does it mean? He should not withhold the assent. Yeah, pocket veto is always there because there is no time limit. Pocket veto, see let's understand this way. Veto is assertion of no. Okay, positively saying no, or whatever you want to say. You have to assertive in saying no. And there is assertion of saying yes. There is in between, if you are not doing either of the two, which the constitution says that there is no time for saying yes or no. Therefore, pocket. So the veto, calling veto is also not very correct. Veto is just like he is holding for some time. The reconsideration, after reconsideration, he cannot say no. He may take a time to say yes. Okay, but he cannot send again for the reconsideration twice. Yes, hold it, but that is not an, what is called an absolute veto. When we say that not giving an assent, it is about the absolute veto. See, the pocket veto word is also not there. See, these are the conventionally we started using it. The Constitution only says that he should provide the assent after reconsideration, or he cannot withhold the assent. The time limit, since it is not mentioned, I have explained that in case of US it is 10 days. And after 10 days, it is deemed to be passed by US president has given the assent. So that thing is not there. So obviously, the situation might come where there will be a possibility of not taking the decision. Okay, but when we say that veto, it is saying no. Okay, it is an absolute veto. Pocket veto is just a conditional or the situational thing. पॉकेट विटो नो पॉकेट विटो में नहीं दिया होगा वो नो नो विटो लिखा होगा देयर इज नो विटो और पॉकेट विटो लिखा हुआ है नो विटो पावर बिकॉज कॉन्स्टिट्यूशनल अमेंडमेंट ही हैज टू गिव द एसेंट ठीक है उसमें भी पॉकेट विटो आ सकता है आना है तो क्योंकि टाइम लिमिट मेंशन नहीं है बट व्हेन द क्वेश्चन कम्स वेदर देयर इज एनी विटो in constitutional amendment that there is answer is no. You don't think like, no, the time interval is not given, therefore the pocket veto can be there. That's not the thing. Okay. Is any other doubt? Yes, please. Ah. Hmm.
And right to die hasn't been really recognized by law.
Yes.
So, sir, if tomorrow there's a question with respect to it, would you stick to it because there are jurisprudential differences of opinion with respect to it?
Yeah, that's not a right to death. Right to death, see, the euthanasia is a very different condition where we call a permanent vegetative state, where there is no possibility of bringing the patient back into the normalcy. That to be based upon the medical evidences. So that's a specific condition. Right to death would have that you, a normal person, taking life of his own. It also does not include the suicide. Although the suicide has been decriminalized, but it does not mean that there is a right of suicide. Okay, so there is a difference. That's a specific condition. Shall we start now? Okay, so the judiciary. एग्जीक्यूटिव में क्या रह गया? पूरा ही रह गया क्या? कौन सा है? कहाँ पे है एग्जीक्यूटिव? ओके, ओके, विल कम टू एग्जीक्यूटिव लेट. पेज नंबर 19. ओके, ठीक है. एग्जीक्यूटिव. Executive, the first is about MP large scheme. That is, Central Information Commission has recently made recommendations regarding the Member of Parliament Local Area Development Fund. Now, see, the thing is, you need not go into the details of recommendations, but you must know the details of scheme, because this scheme is always in controversy for non-utilization of fund or misappropriation of fund, etc., etc. Otherwise, it is a very, very important scheme for the rural development. So we'll see that some of the basic aspects of this particular scheme. First of all, the scheme is not limited just to the member of Lok Sabha, so all the MPs, Lok Sabha, Rajya Sabha, and the nominated members. So as per this scheme, they get the 5 crore rupees per annum for the local area development. So it's quite logical. Lok Sabha members will go for their own constituency. So their district or constituency, they will develop. But when it comes to the Rajya Sabha, the question appears they don't have the constituency. So what they have is a state. They are the representative of particular state. So in that state, they can pick up any district, two or more districts also, and they can distribute their fund. And in case of nominated member, they don't have the state also, so they can pick up um, any state, any district from any particular state. So there is no limit on that. All of you have got this point. Lok Sabha, their respective constituency. Rajya Sabha, any district from their state, and nominated members, they can pick up any district. Then there are certain significant features. One of the important thing you should remember is a ministry. There's a Ministry of Statistics and Program Implementation. That's because time and again, in every scheme, they have this habit of asking which ministry the scheme belongs to. So you should always, whenever you are going through ministry, put an eye on the which ministry, under which ministry it comes. So it's here, Ministry of Statistics and Program Implementation. Then there are certain particular details. First detail is 5 crore rupees and 5 crore per annum. Again, there is a year marking of the fund out of the fund which is given. Okay, that is 15% fund should go to the SC and 7.5% should go to the ST population. There is quite possibility if the ST population, significant ST population is not there, then they can go for distribution of this fund, 7.5% out of their constituency also, if the tribal population is not there. Then, yes, you have to remember this thing, although this is a name of the scheme is MP, local area development, but MPs are only recommendatory bodies. Although the recommendation almost becomes a binding, but it's nothing like that, that everything, whatever the MP is going to suggest, it will have the place in implementation. Implementation agency is district administration. And the district administration has to give the certified report to the state government that this much of money has been utilized to the state government. I remember this, the word here is state government, not the union government. Union government, it's a ministry. So DA is a, DA, that is district administration, is a implementation authority, and MP is a, yes, that is a recommendatory body, okay, or recommendations are being made. So these are the some of the details of the scheme, okay. The controversy mostly related with the siphoning of fund, non-utilization of fund, misappropriation of fund, etc. So that's the main question. Next is the Yes. Mm. That will not be there. It will be under this ministry. Implementation will not be there. Okay. Both of the two options will not be there. It will come under this ministry, likewise. Yes, but it can be like whether the MP is a final authority. So, a recommendation of the word, that word is important. MPs, district administration. No, see, some UPSC never goes into that particular thing. Many times we see in the test series, they tweak very, very small thing. There is no gray area when you see the UPSC's paper. It's a very black and white. Okay, kabhi, one or two questions here and there, but most of the times there is a clarity. ठीक है? See, the thing is, you should, thinking is good, and you should not overthink. Like in polity, it happens all the more. President power is there, and president is not there, vice president is. Then the question comes, if president and vice president dies, then, and some CGI dies, then somebody else, the senior most, he dies, then everybody dies, then who will run the parliament? So there is no limit. So sometimes you have to arrest your thinking. Okay. Prior sanction. See, this is a very important thing. Prior sanction, this is related with the issue of investigating the corruption. And here the thing was, there are two aspects when you see for the investigation of any kind of investigation against the government officials, public servants, judges, magistrate, etc., etc. So the present position is there is a certain immunity which is granted to the public servant. And that immunity says the prior sanction of the government is required before the prosecution. Now, the word is before prosecution. But there are different stages. One is investigation, okay, inquiry, FIR, investigation, and prosecution. So the point is, if you see the investigation stage comes first, and then the prosecution. Now, the present position is at this stage, the government sanction is required that to go ahead with the prosecution against the government servant. But now the Rajasthan government has come up with this bill, and they are saying that for the investigation also the prior sanction is required. Now, the very point is, you can imagine that if the, see, the thing is, the rationale behind why the government permission is required is to stop the harassment of the honest servant, etc., okay, to provide the immunity to the honest people. But the point is, unless and until investigation is done, on what basis you are going to decide whether the person is honest or not? Okay, so the thing is, this is actually curtailing the complete scope of even investigating the matter against the person. If there is allegation, the allegation has to be investigated. Without investigation, how will you come to know that whether a particular allegation has certain merit or not? Only when investigation happens, the government may decide that there is no merit in this, so the prosecution is not required, so that the further harassment of the servant can be, public servant can be stopped. But here we see that it's more about increasing and enlarging the power through which, under the disguise of protecting the honest officers, there is a more increase in the power of the executives. So the Rajasthan becomes the first state to do so. It has been withdrawn? Okay, so that's the current update. Yeah, it is bill, it is already written. We will again come to this fact, this particular thing. These are debated again in case of, there is a current bill, that is amendment to prevention of corruption. Okay, usme bhi, these are kind of provisions. So just remember, so if it is withdrawn, the point is, again, there is no point in discussing. But just remember, these are the points. Rest of the things, nothing is there as such. Section 19, Prevention of Corruption Act, you can just remember that point. That is where, in that particular act, presently it is written, at the prosecution level, the sanction is required. The next one, the app for MPs to track the development. Okay. So this is the e-governance initiative. Government recently introduced the app UPAI, okay, Unified Planning Analysis Interface Solution in English. I think iska kuch, UPAI, yes. They have these catchy words, okay. UPAI is solution. That's why I was wondering, UPA कैसे आ गया इसमें, India के time में. That's a very, okay, UPAI, Unified Planning and Analysis Interface. So this will track the member of parliament to track the development. So this is basically the IT platform which will be given to the MPs to track, obviously including the MP large scheme and any kind of activities which is there. So there will be obviously the data, social data and other economic data which will be there, and district-wise you can see the disbursement of fund, etc., etc. It is monitored by PMO. That's important thing again. So a particular thing monitored by PMO. It is not there at the MLA level. There is they are saying that in the next phase it will be extended to the MLA level. So just remember this word UPAI. So they might ask you one liner itself. UPAI is related with the solution of this and that and crisis management, disaster management, or anything of that sort. So it's related to MP LAD. This one, PMO has a 3-layer structure, e-governance monitoring structure. What is that structure? PMO office, PM, e-governance platform, Pragati platform, have you heard of? So there is also a Pragati platform at the national level, where the PM office, along with the cabinet secretaries, as well as the state secretaries. So there is a 3 layers. One is the PMO layer, second is the CabSec, which is a horizontal, and the last one is the state secretaries. So all these 3 are brought into the single platform, that is a Pragati platform. Okay, that's also a significant. It's under the PMO. So it's an initiative of the e-governance through which the Prime Minister or the PMO office can keep eye on the progress of the union ministries and the state ministries also. Is it fine? Pragati. Ministry of Housing and Urban Affairs. So it's nothing but there were 2 ministries which have been merged into one. Now the new name is Ministry of Housing and Urban Affairs. Okay, so there were earlier. Yes. Next is what is this? Yes, there is nothing here as such to discuss. Just the name has now been changed, and the 2 ministries have been merged into one. Rest of the things are just given as a matter of fact with regard to the current bills in urban areas like RERA and this street vendors bill. Okay, the next now. Election, I think we have done. Judiciary. As judiciary, the first is Article 142. Article 142, see, there you have to remember this one word, that is doing complete justice. This is the extraordinarily power of the judiciary. So apart from whatever the verdicts they are given, okay, they have some extraordinary power. That Supreme Court exercise its jurisdiction may pass such a decree or make such an order necessary for doing the complete justice in case, in any case, and the matter pending before it. Now, if you see the scope is very large here, and we have seen in the recent times so-called judicial adventurism, judicial overreach, what the thing is going. So, particularly the cases with regard to the verdict on the highway liquor ban, ordering the joint trial for the 2 Babri Masjid demolition cases. So they are invoking this clause of 142, and they are giving the verdicts. Now, for some of the experts, they say that judiciary is going beyond their purview, okay, and entering into the domain of executives and giving directions. So there's a very thin line area where the point can be drawn. If you see, you can say that it is inactivity on part of legislature and executive to take the action. So therefore, the judiciary is stepping in and giving such directions when there is an inactivity and inefficiency on part of executive and legislature. So that's a positive aspect of looking at the things. But there can be a other aspect, okay, critical aspect also. One might say that they are stepping and overreaching also. That's again a main point. The point here we have to remember is they have the power under the 142. And in these days, they are extensively using this power. That's why it is being questioned. Unlimited power, unconstitutional. See, unconstitutional, here it is analysis. It's not unconstitutional. It is 142 clearly states it. Unconstitutional, they are seeing in the purview of doctrine of separation of power. Uncertainty about the discussion. So these are more analytical points. Nothing much to remember. What is 143 article? 143. Yes, President, yesterday we have discussed something original jurisdiction. In original jurisdiction, one of the exception was pre-constitutional treaties. Okay, they will not come under the original jurisdiction. So they will go under 143, where they can take the president can take the advice of Supreme Court. Is the advice compulsory to be given? No? No, there are two aspects within 143. There are two aspects. One is if any matter of public importance, then also president can ask the court to give the advice. This is called advisory jurisdiction. So there are two things in 143. One is any matter of public importance. A president can ask for the judiciary to give the advice. Second is if there is a issue with regard to pre-constitutional legal matters and treaties. Now tell me what is the answer, whether pre-constitutional treaty, they have to give the advice. And in matter of public importance, judiciary can say no also. It's not mandatory for judiciary to give the advice. Again, there is one more thing. Is the advice binding on the president? No, in both the cases, it is not binding, even if it is rendered. So the advice is not binding on the president. But it gives a lot of weightage to the decision that is to be taken by the president, because it gets an legal weightage, because advice which is coming from the apex court. So obviously, it will have a more weightage if you are taking the decision. Okay, so that's the point. Anyways, it was just a passing reference here. Yes? We are coming, that's the next only, okay. A case of a larger bench, okay. See, there are different kinds of benches, if you see. Constitutional bench, when we say, the constitutional bench requires the FIO, okay. That is where the matter of, where the constitutional fact or the law is involved. So it has to be taken to the constitutional bench. Now the rules, these are rules because these benches things is not mentioned in the constitution. So they are the separate. So we'll just, setting up of 9 bench, this right to privacy, 9 bench was there. And the matter was decided quite, you can say that in favor of common people, that right to privacy was upholded as a fundamental right. But in many of the cases, we have seen that matter was important. It requires the constitutional interpretation. But we have seen that because the larger benches were not there, so matter does not got the sufficient attention and it has not been resolved to the satisfaction of the people. Because of this, there has been a lot of hue and cry that we should not have the small benches. Big benches means constitutional interpretation since involved, so there will be variety of the opinion, more wisdom, and the better decision. So here it is, Article 143 states that any substantial question of law relating to the interpretation of question must be heard by the benches of at least 5 judges. More judges means these are all the things. Last point, it is more difficult to overrun the 5-judge bench than the 2 or 3 bench, meaning that the public can have more confidence in the stability of the law. So this is your answer also, okay. 2 bench, 3 bench, 7 bench, 9 bench, 11, 13, etc. At lower level, there is a single bench also, okay. But at the Supreme Court level, these are the things. But constitutional bench, it has to be 5. But because they are saying that since there is judiciary is already overburdened and lot many other issues are cropping up, so they are having a smaller bench, such as this issue of Aadhaar, issue of lot many other things are there. Okay. Yes, it can be overruled. That is what, even what we say, this Keshwanand Bharati's case of basic structure, if there will be a larger bench in the future and they say that there is nothing like basic structure, So there can be a very big trouble for the judiciary in the, but it is not going to. I think it is 13 bench, 13 bench. So 15 has to come, which is very, very big thing. Okay. 9 itself was a very bigger thing for the right to privacy. ऐसा नहीं है कि मतलब 25 लोग हैं 31 है तो 15 तो हो ही जाएंगे ठीक है yes overruled in fact that's also the problem why they are saying that bigger bench should give the decision because when the smaller bench gives so there is again a review petition and these are filed up so there is always a expectation of the 5 bench will resolve the matter so again there is a pendency is increasing okay yes it is no, see the thing is now that's what we are saying. Here there is a 5 bench it is written, but the thing is, judiciary are overriding some of the provisions with the judicial rules. Okay, as per the requirement. Yes. Yes. See the thing is, they are not bound to give the same decision. But then the interpretation happens that there is a filing of the review petition happens. It happens. Well, many a times the High Court itself gives the decision contrary to the matter which has been decided by the Supreme Court. No, controversy hai, lekin the point, controversy, it happens. But the thing is, we have seen number of cases wherein the court in the high courts are giving the decisions which the matter has already been settled. See, many times that we see that the judiciary has one power of self-correction also. Self-correction. Okay. Appointment of the High Court judiciary. See, this is again I am not discussing because these are related with the additional and the ad hoc judges. There are already provisions in the Constitution. Here there is nothing to be discussed because apart from the regular judges, okay, there are ad hoc judges and additional judges. So there is a provision for the High Court and the Supreme Court. So there is nothing as such to be discussed here. Additional judges, acting judges, and ad hoc judges. These are the 3 categories of judges. These are the for the crisis, if there is a quorum is not there or there is a pendency of cases are there, etc., etc. Next is the ADR issues. Okay, that is related with again where we see the alternative dispute redressal. So there are, if you see the in case of थोड़ा सा AC वो कर दो बढ़ा दो. It's not functioning? Question, okay. Yes. Okay, curative and review petition. See, once the matter is resolved, okay, so there are 2 aspects. Twice you can make an appeal. Okay, so one is the curative and another one is the review. So there, again, you have the hope to go to the judiciary twice. Essentially, the matter in both the cases, we have seen that the same bench, okay, it goes to the same bench because if it goes to the other bench and every time it happens that in review and curative petition, if the court starts giving the other decision, then it will question the credibility of the court itself. All of your understanding? See, these are again not and rights. These are in a very exceptional circumstances it happens. When the Supreme Court already gives the decisions, you can file. Curative means cure. Okay, review means reviewing the decision that has already been taken. Like it has happened in this 377, this IPC 377, where the Supreme Court has said that which was decriminalized by the Delhi High Court, again criminalized by the Supreme Court. Okay, I hope everybody is following 377 IPC, the decision on it. So again, initial petition. Then it is a review petition has been filed. That the matter has not been sufficiently dealt. So you can file again. But the point here was it has been taken to the larger bench, which is an unprecedented thing. Why there was a lot of enthusiasm and positive expectation about the verdict is it is not an precedence that generally the same bench takes the decision and just they take the overview. Otherwise, what will happen then? There will be a lot of lack of faith in the public that this bench, that bench, and there will be again review and curative. Have you understood? Okay. So these are exceptional circumstances again. These are not the norms. Okay. 142 is not a norm. Curative review petition is not a norm. Article 136, that is a special leave petition, is not a norm. This should be sparingly used. Special leave petition, review petition is the Supreme Court itself is giving, and they are reviving their own verdict. Special leave petition is any court, any bench in India, any matter, tribunal, non-tribunal, at any stage, whether it is a pending and the verdict is given, Supreme Court can take the particular case with them and they can resolve the matter. No. This is, see, the thing is, they say that, say for example, writ petition है, तो उसमें क्या लिखा हुआ है कि 226 as well as the 31. So generally you should go to them. But say for example, tribunal is there. Supreme Court is saying because you go to that, you exhaust that first, and then come to us. But it is nothing like that. The Supreme Court has a power to take to itself any matter at any stage and any court pending to itself. Understood? So that is a special leave. Again, that is that power should be sparingly used. It should not be a norm. And most of the times, it declines. Okay, but obviously the lawyers must be knowing it's a bread and butter for them, because when the decision is given, special leave petition is the last hope. So mere filing of the case itself takes a lot of money. What verdict will happen, whether the Supreme Court will accept or not, that's a different case altogether. Appointment of the High Court, we have done. ADR mechanism. Okay, ADR mechanism, this is in the news because there is a special committee, that is B.N. Sri Krishna committee, has given the report on institutionalization of arbitration mechanism and suggest the reform. So you should remember this committee, that is B.N. Sri Krishna, on the ADR. So if you see the ADR mechanism, so there are alternative dispute resolution. This is loosely called as out of the court settlement. I'm saying loosely called, okay? Not so out of the court settlement, because we see particularly in the context of pendency of the cases and increasing burden on the court. So this is an alternative dispute resolution, out of the court or alternative dispute resolution. There are different mechanisms here. One is the arbitration, second is the mediation, and third is the conciliation. In case of arbitration, it comes very close to the judicial mechanism only. Only difference is, here the party which is going to give the verdict is agreed by the two of the parties. So here it will not be judiciary. Say for example, two parties are there, A and B, and there will be an arbiter. So A and B accepts that this will be our arbiter, and whatever the decision that will be given by the arbiter will be accepted by both the parties. So it's like a court only, but the thing is, instead of the court, here there will be an arbiter. So that is called arbitration. Second is about the mediation. Mediation, A and B is there, and the third person mediate between the two, negotiation, so as to reach to the particular decision. Okay, amicable decision based upon their consent. And third is the conciliation. Conciliation, again, A and B parties are involved. There is a counselor, and the counselor helps them to reach to the decision. But here, the counselor, even after giving the decision, it is not binding on A and B. Okay, they might say that, okay, you have given the decisions, but one of the party might not agree to it. Okay, but in arbitration, you have to agree. But again, these are very generic terms and generically defined. Specific laws are there, Arbitration and Conciliation Act, etc., etc. So there is a legal act, statute. Based upon the statute, so these generic terms becomes more objective and more specific. Okay, that's not required. Just remember this much. And we have some of the system like this Lok Adalat. Okay, the famous one. And this Lok Adalat, it also has a statutory backing. And Lok Adalat has a statutory backing through the National Legal Service Authority Act, NALSA Act. NALSA institution which was been created under the Act, and the NALSA has a function of organizing the Lok Adalat. So there is an Act. In fact, before the Act, you have one constitutional provision, Directive Principle of State Policy, DPSP, article number 39A, free legal aid to the needy person. So free legal aid to the needy person, 39A is there. As per the 39A, the state has obligation to help the poor people to have a justice. So under this, they have formed this act, NALSA Act. Under the act, the authority was created, that is a national legal authority, and they have lot many functions apart from organizing the Lok Adalat. Organizing Lok Adalat is one of the function of National Legal Service Authority. Other functions are like any kind of assistance in terms of justice that is required to be given to them. So there can be a different ways and means of assisting. So these are the points you should remember. Gram Nyayalaya is another thing, but Gram Nyayalaya is not specifically this, you cannot say that it is ADR, it is altogether a different thing because judicial magistrate, JMFC are involved into the dispensing the justice. So there are judicial people also and non-judicial people also. Yes. Hmm. Yes. Okay. No, it has yet not a statutory backing because see the thing is, it's not even correct. Unless pro bono means what? Voluntarily you have to assist the voluntary and free of cost. So that becomes a too much condition to, you can say that elevate a person to the, it has yet not got the legal. See, the thing is, collegium goes as per the conditions which are mentioned, and there are only 2 or 3 conditions. Citizen, 10 years of service and 5 years of. So these are the things. Apart from that, they see the antecedent record, matlab, whatever the record is there, if there is any case or not, the collegium system work on that principle. Any good things you are done is a more of a tick mark, but it cannot be a disqualification. You are not a pro bono. See, the thing is, apart from the constitutional mandate, citizen, and the number of years that you should have served, apart from that, your personal record, that's it. Matter of integrity, the merit, how many cases you have solved. So these are more of a, collegium system goes into that to check your integrity and the merit. And obviously the seniority. These are 3 things which will be seen. Obviously all system is opaque. Who is who, of whom, that becomes uncle judges or what they call. So that becomes a very prominent in collegium system. Okay. Hmm. Yes. No, no, not uniform. See, wherever president is mentioned, there is a president. Wherever the CGI is mentioned, it is a CGI. It's not in uniform for all the 3. It is different again for the High Court and the Supreme Court also. The names are also little different. Okay, just go through that. If CGI is mentioned, because see, the thing is, it is an ad hoc basis. So it is, you are just taking for the sake of tiding over the crisis or the pendency, whatever. For each specific appointment, there are certain criteria why you are taking. Okay. So yes, it is CGI only in that case. It's not uniform. Yes, NALSA, we have done this Gram Nyayalaya. Gram Nyayalaya Act 2008, it is for the state government to establish the Gram Nyayalayas in consultation with the respective high courts. Okay, so that's why we are saying that it is not completely a ADR mechanism. Okay. Now let's come to the tribunal. Tribunal is a ADR or what? What do you think? Tribunals is a Alternative dispute? It's a quasi-judiciary, it's not completely, but yes, certainly it is out of the court only, okay? So in case of tribunal, so if you see here, the Law Commission has suggested about the detailed procedure for improving. Again, we need not know, we need not have to go into this. Just you should remember the basics of tribunals, and particularly, is there any constitutional provisions for the tribunals? Yes, 323A and 323B. So the special aspect of 320A is related with the administrative tribunals. Can you give certain examples of administrative tribunals? CAT, SAT, ZAT, anything else? Hmm? And dealing with the matters, other matters, 323B. What are the other matters? Lot many matters are there. At least you should tell one or two. Arbit tribunals. Taxation matters. Okay. Yes, taxation matters. Environment matters. Okay. Yes, anything which is not. See, the thing is, administrative tribunals means grievances of the public servants. Okay. So the CAT, that is Central Administrative Tribunal, and the State Administrative Tribunal. Apart from that, there are other disputes. See, the thing is, one of the reason, it's not just taking the burden out of the judiciary. There are other rationale also creating the tribunals, because there are certain areas which requires a special expertise. Okay, say for example, matter of taxation. So you require a very specific acumen. The people from the tax are required to be there in order to adjudicate the matter. If environment matter is there, people from environment are required, environment experts. So one of the reason is obviously to take out the burden out of the judiciary. Second is the matter should be resolved through the expertise. The third is speedy disposal of justice. So these are some of the aspects. Also remember that in case of, since this is a quasi-judiciary, the composition is also the quasi, because there are the members from both, judicial members as well as the administrative or the experts from particular field. If it is a NGT also, that is National Green Tribunal, then we have the judicial member also, which is a retire or the acting, and second is the expert from the environment also. So likewise, so it is not completely headed by the judicial members, it is judicial as well as the administrative members. So these are the... Yes, initially it was not, but this Chandra Kumar, what is this case? Chandra Kumar case 1997, so the court has said that it is like diluting the power of the court. So the appeal can be made and it should go to the respective high court benches. Yeah, that is the where we see the criticism on the tribunalization of justice. जो बोला जाता है कि as such it is not reducing. Now they are saying that may be the reason the Law Commission has come up with the report now. Now they are saying there are a lot many issues with respect to tribunals. One is, anyways, if you are taking the appeal now to the High Court, if the matter is not finalized by the tribunal, so where is the ending the pending burden? But they say that not all the cases go for the appeal. Okay, so therefore, if at least 50% of the cases find its final conclusion at the tribunal level, so it reduces. Second important danger, or you can see that the detail thing is, we have said already that they have the judicial and non-judicial members. Now, who appoints these non-judicial members? These are appointed by the government union executive. So therefore, again, there is a question mark on the impartiality of these decisions, because it is an extension of executive power into the adjudication of the matter. So there is also a conflict of interest also. These members are not independent. Most of the times they are not financially independent. They draw the salaries out of the different ministries. Again, that becomes a part of government. Appointment is with the government. Removal is with the government. So there are a lot many issues with respect to the tribunals also. Okay, independence of. In this context only, there is a reforms that have been suggested. Chandra Kumar case, yes, appeal is there. That case is very important because time and again it has been highlighted. Chandra Kumar case, where the appeal against the order of CAT shall be lie before the divisional bench of the High Court. Next, there are certain schemes which have been launched recently. All these schemes are related with the dispensation of justice. So just one by one, we will take it. One is the tele-law initiative. See, the objective is, again, you have to remember this 39B, 39A, 39A, that is a free legal aid. So in this case, if you see this tele-law initiative is with respect to, now tele, we know that, okay, that is what is tele? Tele-education, telemedicine, huh? Signals. Distance, okay. Okay. So that is where the distance comes here. So if a person is staying in a rural India, so there are what is known as common service centers. So in the common service center, so through the tele, there is a connection that can be established between the people in the rural India and the judiciary at the higher level. Okay. So the legal aid can be obtained through this particular mechanism. So that is what is the tele law. Here there is also something called as the paralegal volunteers. Paralegal volunteers. So the paralegal volunteers is nothing but it's a first interface, because this common man would not be knowing how to get connected with this mechanism. Plus here there will be judges or advocates or the lawyers who will be tendering certain advices. So these advices may not be understood by the people in the rural area. So there is a connecting link. There is an interface. That interface is paralegal volunteers. As something, if you can relate with the ASHA workers. ASHA is the first interface of the people with respect to the NRHM, okay, or the NHM, National Health Policy. So it's ASHA, it's like that only, okay. Here also they are promoting the women as a paralegal volunteers, okay. In ASHA, though, obviously it's all women only. So here also there is a thrust on the training the legal, the women PLVs, so as to promote the women entrepreneurship and the empowerment, etc., etc. Okay, so I hope the point is clear. Tele law. So remember this common service center, PLV, and the connecting link. Next is the pro bono legal service. Somebody was saying away. So pro bono is a voluntary and the free. Now, in case, see, the thing is, there are because access to the judiciary is very limited because of lot many reasons. One is complexity. Second is obviously the financial thing. So what is a pro bono? There will be a website, okay, and website will be hosting. There is a voluntary, like all the lawyers can nominate themselves as a part of the pro bono initiative. So they can give their names on the website that we will be available for providing the free and the legal aid as and when it is required. So there will be a platform. So the names of the lawyers and this thing will be there. And the people whose petitions are pending, they can access the free legal aid through this particular thing. So pro bono is a side of voluntary and the free. From the side of the judiciary, the name is given. So legal aid and advice from the pro bono lawyers. Those lawyers who volunteer for such things will be duly recognized. Recognized, obviously, there will be recognized. Somebody was saying that it will be a criteria for the, for what you said? Senior advocate. Okay, so it is nothing but seeing the track record. Okay, yes, they are rendering some service, so it can be. The next one is the Nyaya Mitra. Nyaya Mitra. See, the thing is, again, this is again related with helping the people in dispensation of justice. But the most important point here you should remember, this Nyaya Mitra platform is for pendency cases. Your case is pending and it is pending more than 10 years. Okay, so it means that the matter must be complex. There are certain hassles. So whatever the issue is, because of which the case is pending. So in such cases, to reduce the pendency of the cases, in a selected district, special focus is given. So here again, there will be a legal assistant will be provided to them. And how to get those things, because there is a national judicial data grid. So from that, you can easily find out that which are the cases which are pending more than 10 years. So that is about the Nyaya Mitra. Next is, yes. Yeah, where it is not there. No, there will be. Matlab, lawyer has to nominate. You cannot force upon someone to become a pro bono, giving a pro bono service. Ye- Yes, how they will know? I have given, see, there are NALSA is there are certain legal NGOs are there. In fact, that is next point is there will be an integrated case management system, and see, everything will work in tandem. This is one of the thing, as I have said that 39A के अंदर बहुत सारे initiatives लिए गए हैं, okay, through which they are trying to help the people out. So this is a technical platform for sure, but obviously there will be more popularization through different mechanisms. Like NALSA will be there, lot many other mechanisms. ठीक है? This is see, Nyay Mitra has nothing to do with that. Okay. See, the exclusive ruler नहीं है, सबके लिए ही है, but the point is generally the access of judiciary to the rural areas is not there. So those people are not aware. So by and large, they will be the beneficiaries of this. ठीक है? Yes, the next one is the access to the justice project for the marginalized people. This is mainstream legal literacy through the CSC in the Jharkhand and the Rajasthan. This is particularly the UNDP program. See, this is again one of the component where there is a no legal literacy is there. So UNDP is trying to step in and trying to educate, particularly Jharkhand and Rajasthan. I don't think so that is very important, these components, small. National Mission for Justice Delivery and the Legal Reform. This is a broader aspect, okay. National Mission for Judicial Delivery and Legal Reform, all e-judicial issues, any kind of judicial reform. So that's a bigger plan. 2011 ka. Again, that's a very general things, not to be specific. And all whatever we are doing is nothing but the part of that. Next is integrated case management information system. This is important. This is nothing but the e-judiciary at the Supreme Court level. Now they have started with it. Integrated case management information system. Integrated case management information system has been introduced in the Apex code for the digital filing. Digital filing, this is e-judiciary. So from the level of the filing, tracking of the case, verdict, summoning, everything end to end, from filing the petition to the final verdict, it is digitalized and it can be tracked. So the beginning has been made from the Apex code. Over a period of time, obviously, it will percolate down to higher court and the lower judiciary. But as of now, it has been started. So ICMIS, that is again a part of the Digital India broadly. Next, cooperative movements in India. Recently, the Prime Minister has talked about the importance and contribution of cooperative sector. See, again, these are all generic points. You need not have to worry about whatever the current, only the focus is, it means that you should go through some of the cooperative provisions wherever they are in the constitution. So one is the cooperative constitutional amendment, that is 97th. Okay, and there are, apart from that, there are fundamental right. Is there any cooperative word is mentioned? 19A. That has been revised. Obviously, 97th only has brought in this word. Okay, 19 में कहाँ पे है? Formation of association and the cooperatives. Okay, then there is a directive principle also. 43, 43B. And 43 also, loosely there was a word. So these are some of the things you should remember. Rest of the things are not important at all. These are all the past committees which have spoken about the cooperative movement. So I don't think so that's important. Just remember this 97th and these things. 97th you should do if you want to, because there is a, like, say for example, 73rd and 74th, there is a separate chapter. So 97th amendment also has added the different chapter altogether. That is the cooperatives. So those provision has to be seen. Next is judiciary and RTI. Judiciary in RTI, this is again more of a tussle between whether the judicial transparency is related, whether the judiciary comes under the RTI or not. So if you see the section 2H of RTI, it defines what is called as the public authorities. So, but the judiciary has overridden some of the provisions of the RTI, and they are not coming under the ambit of RTI. Okay, much of the things. So that is what, there are certain judicial rules, and they say that if we give the information, then it hampers the maybe the integrity, autonomy, and the not transparency, we cannot say that transparency because it will be more transparent. Independence of judiciary, what is their favorite word is, it will be not independent. Okay, so they are still out of the purview of RTI through their specific judicial rules. One more thing is RTI, if you see within the RTI, there are appeal. Okay, first of obviously the matter, whatever you ask for through the RTI will be given by the PIO. But if you are not satisfied with the PIO, it will go to the first appellate and the second appellate. First appellate, it will be mentioned by the PIOs later that you have to go to this authority to give the appeal. Second appellate is fixed. It is, what is the second or the final appeal? CIC, yes, CIC in case of central government, central related information, and SIC, that is a state information in case of this. Now, that is a final one. CIC and SIC, whatever they say, it's a final one, and they have said that there is a clause which says that the judiciary is prevented from taking the appeal of RTI. It's where we see that RTI law also does not give the much power or the scope for the intervention of the judiciary into the RTI Act, and the judiciary also not letting the RTI to creep in through the judicial rules. That's it with regard to this. Just remember this section 2H, public authority definition. And what is a section of RTI, exceptions to RTI? That is section 8. It's a very broad section. What are the things which does not come under the ambit of RTI? All these things are mentioned in the section 8. Section 8, although for the namesake it is exception, but these days it is becoming a more and more bigger one. It's like a ninth schedule. Okay. It should be sparingly used, but everything, when you don't want judicial review, you put it in ninth schedule. So the same thing is happening here also. Next is regulation of NGO. This is important one because these days we have seen that lot many controversy with respect to the NGO issues and FCRA. That is what is FCRA? Foreign Contribution Regulation Act. Now, if you see this FCRA Act, although we have started saying that NGO funding of foreign funding of NGO is equal to FCRA, that's not the thing. FCRA has a larger ambit. Okay, FCRA has a larger ambit in saying that it is not just about the fund or the gift or hospitality, any kind of hospitality. If you receive, that's also come under it. So it can be a cash or the kind. If you receive. So the foreign contribution can be in the form of fund or the gift and hospitality. Second thing is it is not just NGO, it can be an individual, it can be in government, it can be company, it can be any other thing. Okay, so you should know these provisions. See, the thing is at the bottom it is given. It regulates the acceptance and utilization of foreign contribution or foreign hospitality by certain individuals also, by associations and by companies also. So the ambit is big. Initially there were political parties also. If you see the origin of this particular act, although it was in 2010, there was an earlier time to regulate the foreign. So it was more about stopping the influence of foreign into the democratic process, so that the funding in the political party should not come and the electoral process or the democratic process should not get influenced by the external agents or the foreign bodies. But the thing is, over a period of time, we have seen the shift of attention from the political party funding and etc. to these NGOs and etc. In fact, recently there has been one act that has been passed which has given the retrospective effect also. If you are reading the news, where both the principal national parties, Congress and the BJP, it's a very rare occasion when they get together, okay, in order to pass the law, because both of them have received tremendous amount of fund, okay, and they come under this particular act. So in order to outlaw that particular thing, so they have retrospectively given the effect that whatever the fund that the political parties are going to get, so that will not come under the ambit of FCRA. So to start with, it was to stop the influence of foreign into the democratic process, but now it has been shifted to this NGOs. Now let's see again further provisions. It prohibits the acceptance and utilization of foreign contribution and hospitality for any activities detrimental to national interest. So it categorically mentioned that such fund and hospitality should not be for something which is detrimental to national interest. It also says that, see, the thing is for which you can take the fund. The fund can be collected only for, and it is mentioning only for, so only for that reason. So there are 5 things here: research, training, awareness. These are the 3 things. Then rehabilitation and relief of victims, that is disaster management, victims of man-made or the natural calamities. And the last one is maintenance of building and the real estate of the philanthropic activities. So these are the 5 things. One is for the research purpose. Second is for the training. Obviously, if you are hosting something new, so the capacity development of the people, so training, self-help group, etc., etc. If NGOs are running capacity building of the people in the local area, so that's the training. Creating an awareness is the 3rd thing. 4th thing is disaster, and 5th thing is philanthropic activities. But in philanthropic activities also, they are very specific. Maintenance of buildings and the real estate for the philanthropic activities. So apart from these 5 things, if they find that there is a diversion of funds, obviously the FCRA, because FCRA regulates the thing. And which ministry is responsible for keeping an eye on it? Yes, Home Ministry. There is also one act that is a FEMA, okay, under which certain foreign contribution is given also. That FEMA comes under which ministry? Finance Ministry. So now, in fact, the Home Ministry is requesting the Finance Ministry to pass on the power of the FEMA and with regard to the foreign contribution so that they can scrutinize. And we have seen that this 30 lakh NGOs are there and they have been scrutinized, and there has been a registration has been cancelled of how many NGOs? I think 90% of the NGOs they have found are non-transparent in some other way. Okay, only I think 30,000 out of this 3 lakh, whatever the number is. The point here is the regulations are quite strict now, and there has been a blacklisting of many of the NGOs. Okay, Ford Foundation, Greenpeace, these were being blacklisted for some time. Okay, so that is it. You should remember these four, 5 things. There is fund and gift, not only for NGOs, it is for the company, it is for the any kind of association, that is obviously NGO. It can be an individual. It cannot be for the national interest, not national interest, any detrimental to national interest. And the last one is, it is specifically mentioned in Act that it is for the 5 things. That is research, awareness, training, disaster, and maintenance of real estate for the philanthropic activities. Okay. So that, yes, please. No, not. No, see, the thing is, see this, if you read here, there is a box, okay, to monitor the NGOs under the FEMA Finance Ministry, as many of the international donors, such as Ford Foundation, Canada International Development Research Center, are registered under it. So this Foreign Exchange Management Act, so through which there was a routing of funding in initial time. So from where the routing is happening, likewise you have to. But the matter with respect to the registration and all for the NGOs in India is with the Home Ministry. Initially, there was only one time registration. Now there will be a review also. 5-yearly review will be there, whatever you are doing. So initially, it was like you get registered, you get the fund, and you will not be reviewed. Registration will not be cancelled. Now they are saying that registration will also be reviewed 5-yearly. So not both the things simultaneously required. Some of the NGOs which are receiving particularly this donation is coming from this, so they are registered under the FEMA. No. There is, see, the thing is how what they are saying is these companies have already find for them is more easier to do. The Ford Foundation, they started long time back. So that time they registered and the funding is happening. That's also one of the reason Home Ministry is saying that we are not able to scrutinize properly. So pass on that power to us also, so that it will be under the one umbrella. And that is where we are saying that they are saying that the new amendments are required into this. Yes, now the next one is criminal justice system. Criminal justice system, there is one report. Just now we have seen this ADR के ऊपर कौन सी committee थी? Yes. Yes, Justice B. N. Sri Krishna. That's also name important. And this Malimat committee on the criminal justice system is also, you remember, because this is in the news for quite some time, and there has been a lot of thrust with respect to uh, reforms in criminal justice system. Criminal justice system, if you see the dependency of the cases, etc., there are lot many areas where the reforms are required. So we say that the dependency of cases is there because we don't have the human resource. That's just the one part of the story. Okay, it starts with the police system, because whatever the judiciary is going to do, it is based upon the investigation. And investigation in India, okay, except for central premier agencies like CBI and this thing, and almost all the cases it is done by police. Okay, police has both the powers, like law and order as well as the investigation. And most of the times we have seen that the investigation done by the police is very shouty. Okay, it does not find any merit in the court of law. So we have to revamp the system from that. In fact, there is a suggestion by the Supreme Court with respect to police reforms, that investigation and the law and order, that function has to be separated, and there should be a dedicated force for the investigation also. So right from the investigation, then prosecution, and then the prison. These are all three parts of the criminal justice system. So when we say the reforms are required in investigation, reforms are required at prosecution level, that is within the judiciary. Investigation, obviously, it is more of a police reform. And the last one is the prison reform. So the whole package is about the criminal justice system. And if you see in India, police, law and order and investigation, both the functions are there, but 90 to 95% the police is involved in the law and order thing only. Because investigation not only requires the time, it requires the expertise also. Okay. In contemporary time, if you see, it becomes all the more difficult. So you require a very person with great acumen who has like Sherlock Holmes type something is required. Only then the matter can. Otherwise, crime patrol one ke investigation karna chalu hoga, so difficult. Okay, so that's all the thing the story is about. You did not have to go into this. Just remember this Malimat committee, and it has an extensive reform they have suggested. This all the same thing is written here. Nothing much. Next is the Chakma Hajong refugees. Yes, these are Chakma refugees. They used to, they were coming from the Chittagong hill tracts. Okay, from Chittagong hill tracts to, yes, please. Okay, that was not required. That's why I skipped it. But the thing is, inquisitorial means the court itself is also involved in the investigation of the things. Generally, courts are not investigating. Courts are advising the investigation, which is done by the neutral agency. Court itself is just a third party, which are saying that let's investigate the matter. Now, the investigation will go to either the police or the CBI or NIA or for that matter any other agency. So the agency will conduct the independent investigation. That investigation will come to the court, and court will take the interpretation of that investigation. In some of the cases, court gives the direction, court assist. So what is this particularly in these two cases? One is there is a more involvement of the court itself in the investigating the matter. And generally when we say that investigating the matter, there is a prosecution side and the defense side. So when we are investigators, when the police is investigating, police is trying to prove the case in favor of the prosecution. Okay, and there is a defense. So if the court is getting into this, favoring the investigation, it means that it's not an neutral. Okay, somewhere it is coming to the side of the prosecution. I hope you have got the point. Okay, so the role of the judiciary with respect to investigation, on the basis of this, parameter, there are two broad classification. That is what is the inquisitorial, where it is a legal system where the court or the part of the court is actively involved in the investigating the facts of the case. Okay. Presently, we have the system that is more of a adversarial system, usually followed in India, where the role of the court is primarily that of impartial referee between the prosecution and the defense. So let the matter is investigated by somebody else, we will neutrally analyze whatever the investigation that comes in the court of law. Okay, have you seen the Jolly LLB? So court knows that what is there and what is not there, but they wait for the investigation to come, but it does not come, and therefore Salman Khan will not get convicted. That's simple. Okay. Okay. No offense to the fans of Bhai. Gym wale jane wale bhai log. Soli Sorabji committee is also on the police reforms. Okay, police reforms. They have given the extensive reforms on the police reform system, and Police Act Drafting Committee. See, the technical name I don't know. The most important one is the Prakash Singh case. This was a PIL. See, this 2006, there are the 7 points. Supreme Court has given the 7-point direction. This one, Supreme Court direction in the Prakash Singh case 2006. Okay, this was the PIL filed in 2000, I think in 90s, and the verdict came in 2006. It's been 10 years now. There has been no action that has been taken. So that's the most important, significant. Whenever you read the police reforms, this point will be always highlighted, that the Prakash Singh case and 10 years of pending of the police reforms. Rest of the things are, see, the thing is, there may not be a particularly on, this is an ARC. ARC may, one of the reports, okay, will be talking about the police reforms. Likewise, there are different things. I don't know the Soli Sorabji committee's technical name, don't know, but Soli Sorabji was also on the police reform itself. Okay. Yes. The court be given the freedom to question the accused to elicit the information and draw an adverse inference against the accused in case later refuses to answer. See, court be given. See, the thing is, if yesterday I have spoken about fundamental right, that is Article 20. There are 3 things. There is no ex post facto legislation. There is no double jeopardy, and there is no self-incrimination. So this is the third part basically. Self-incrimination means you cannot actually force a person to give the witness against himself. Okay. Although it does not mean that you cannot take the DNA and this brain mapping, etc., etc., because they are also indirectly. See, there is a whatever we see this brain mapping, lie detector test, and all these tests. Don't you think that these are the evidences against your own self? Are they or they not? Lie detector test, brain mapping. Yes, they are in a way, because if you see that whatever he will be speaking against or for himself. But the thing is, those legal hassles, now they have put it into the exceptions. Okay, that yes, you can, in spite of he should not give any witness against himself, but that is not a forced one. Okay, they say that we should not go for forcing him in order to give the witness against himself. In case of brain mapping, whatever the voluntarily after giving that chemicals and lie detector may, so he will be speaking about it. Or the blood samples when you are giving, particularly this happens in case of rape cases, or blood samples, etc., you are giving. So these are not contrary. Now here that point is only highlighted, right to silence of the Constitution that protects the accused from being compelled to be a witness against himself or herself may be modified. May be modified means, obviously, in order to get certain information from that accused. So this Mallimath committee is suggesting that this Article 23 will not be an absolute one. It can be modified. Have you understood now? In fact, going beyond that also. See, the thing is, if I am not answering few of the things, okay, then they are saying that the court should be given freedom to question the accused to elicit information. So any kind of information which is required. Now, 23 says that you cannot do it. Now, he is saying that no, if you want to make our investigation strong, some power should be given, more power should be given in order to take the information from the accused and draw the adverse inference. Means adverse inference, what he is trying to say, adverse is adverse to that, what he is trying to say, or he is trying to save himself. Only it is, the simplest meaning is, as per this committee's report, the right should not be absolute. We should increase the scope so that the court has an authority to elicit whatever the information that is required for the investigation if it get assisted. Actually, it is already, okay, if you see the investigation, third degree punishment, this and that, everything is, forget about forcing. It's more about, yeah, matlab, if you see that, if you want to establish a case, so generally we don't have the other witnesses. So we say and go and beat and etc. etc. Lot many things are there, okay, in order to ask or force the person to accept the crime. And most of the cases it happens. Understood? Okay, so that's the meaning. Police investigation to improve the, okay, that's it. Next is the Chakma. Okay, Chakma we were discussing, Chakma Hajong refugees. Chakma Hajong refugees, you should know that what is Chakma. These refugees were coming from this Chittagong hill tracts, most of which located in the Bangladesh. And it is also being mentioned that they have left their homeland bordering India and Myanmar because of the Kaptai Dam project in 1960s. So more of a forced migration. So these refugees were there and alleged, they allegedly faced the religious persecution and entered the India through the Lushai hills of Assam. So these are the trivial things. The important thing you should know that the center has now considered to give the citizenship to these people. Okay, initially they were called refugees or sometimes illegal migrants also. So Chakma, Buddhist, and the Hajong are the Hindus. So Supreme Court has ordered that they should be given the Indian citizenship. So that is the matter which is being considered. Center has moved majority of them now to the northeast. They have just shifted to the Arunachal Pradesh area. Nothing, just two names and government is granting the citizenship. In fact, that takes us to another important bill, that is Citizenship Bill 2016. This is important because it has been created a lot of controversy again, because we'll discuss the points. So if you see the Citizenship Bill 2016, so before that, what is written, we will see that, and we'll see the amendment and what are the controversies. So Citizenship Act writes about the definition of illegal migrant. And what is the definition of illegal migrant in Citizenship Act? Yes, there are two things. One is if you have the visa or the what we call the official documents. If your visa obviously will have certain stipulated time. So you lapsed your time and you are still continue to stay in India. So you become illegal. So you have the good documents, official documents to stay, but the timeline has lapsed. And second is if you are without documents. So these are the two aspects of definition of illegal migrants. So you might have come as a legal migrant, but now you are staying beyond the stipulated time. You become illegal migrant. And second is you don't have the documents in the first place. Okay. Fawad Khan was illegal migrant or what? Legal migrant. Salman Khan ने कुछ बोला था उनके ऊपर. Because see, the thing is, they said that how can you tag a terrorist when they are getting the visa, which is granted by the government of India, and they are staying within the stipulated time. But I दिल है मुश्किल आया फिर बाद में बहुत सारी controversies. But as per the definition, they are not. So visa, if it is there, and within the stipulated time, then they are legal. Okay, now let's come to the amendment. What is the amendment that is being proposed? Now, in case of this, obviously there are certain illegal migrants staying, but now they are proposing that there are some neighboring countries. It just refer to the features of amendment part. It deals with the two categories of people within the amendment. One is the illegal migrant. So first we'll focus on illegal migrant and then overseas card holder. It makes the illegal migrants who are the Hindus, Sikh, Buddhist, Jain, Parsis, Christian, okay, from Afghanistan, Bangladesh and Pakistan eligible for citizenship. So that is an important thing. So even if illegal migrant and if you belong to all these religion except the word M, okay, and if you are coming from Afghanistan, Pakistan and Bangladesh, okay. So these are the only three neighboring countries and rest of the religion except Muslims. So even if you are illegal migrant, you will be granted the citizenship. So that is the amendment. Obviously, this is a bill as of now. And second thing is obviously related to ancillary provision to this. Now they cannot be imprisoned or deported on not having the valid papers. Valid papers, obviously the visa. So that's nothing but the, obviously if they are providing the citizenship, it means that if they are staying here, even if they don't have the visa, so there will not be a punishment. They will not be imprisoned or deported back to their own country. Just go to the next provision, not this OCI wala, last provision. The eligibility criteria have also been reduced from 12 years to 7 years. So this is the third advantage. That is, initially, if you want to get the citizenship, so the minimum time span is 12 years. Now that's also been reduced. If you belong to this religion and coming from these three, so you will get the citizenship within 7 years instead of 3 years. So these are some of the provisions that we see are coming through the amendment. Now, if you see here, the word this or the Muslim religion has been dropped. And if you see the neighboring countries also, the Myanmar is dropped. So M plus Myanmar, which can be the Rohingyas. Okay, so if you see the Rohingyas Muslim population from the Myanmar, the crisis, so obviously it does not apply to them. And that has created, not just Rohingyas I'm talking about, but just dropping this word M and rest of the other things, they're saying that it might hamper the secular credentials of the India. Because see, the thing is, government policy is one thing. How you are doing the policies and etc. There can be a matter of subjectivity that one might say that government is not secular or secular, etc. But the danger of this is, through the legal provisions, you are adding the things into your particular statute, that this will be there and this will not be there. And the constitution says, like, obviously, we the people of India belong to sovereign, socialist, secular, democratic republic. So that secular becomes this. Okay, that's why there is a controversy. I hope the point is clear. Okay, and second provision related with the OCI also. Okay, overseas citizen of India. So yes, please. No, they will not be considered as illegal. These people will not be. See, the second provision is obviously regarding Muslim minority. Yes, certainly. Even if Muslim minority will be from these areas or from uh, any other areas also, likewise Myanmar. If they are obviously the illegal migrant, not all. If they are illegal, okay. So in this case, they are saying that if the minorities are from these three countries, and if they don't have the document, now there will not be a punishment. There will be no importation, no punishment. They will be given citizenship, and the period of citizenship is also reduced. But if the no, for this particular case. Huh? Naturalization, naturalization is the word that they have mentioned. Okay. You are saying that some of the other people who are entering also and wanting through the process of naturalization. Yes. Including this. Okay. Yes, in that case, it will not be. It will be still illegal. See, the thing is, what was the rationale? Obviously, we see that this is something wrong, but what they were saying, the justification for this is, in case of Afghanistan, Pakistan, and Bangladesh, there is a persecution of these minorities. Obviously, the thrust was also not on the rest of the religion. It was more of a Hindu. How many Sikh, Buddhists, Jains, Parsis, and Christians are coming out from the rest of the areas? Okay, from these particular countries. So it is about the minority persecution in these three countries. That's why we are providing the, yes, that is open door policy for these people. Yes, second thing is related with the OCI, Overseas Citizenship of India. So they have added one more criteria for, the bill has widened the ground. Can you find that line? The bill has widened the ground for cancellation of OCI registration by the central government. And one more ground means there are other grounds also that widens if the person violates any law in the force in the country. Okay, so if there is a violation of any law, so the central government can cancel the OCI registration. And you must know that these two schemes have been combined, OCI and the PIO. Okay, both of them have been now combined, and the good provisions of both of them has been merged. So that is it. Rest of the things are more of your constitutional part. Yes. Kiss. Illegal migrant process of naturalization. See, you can. Illegal नहीं अब उनको क्या illegal डाके है. See, the thing is, if you see by birth नहीं होगा because yes. तो इस टाइम तक उनको लिखा है ना यहाँ पे, now they cannot be imprisoned and deported for not having the valid papers. So it means that they will cease to become illegal migrant. They will continue to stay, but the tag will not be there, and after that they will get the citizenship, full-fledged citizenship. ठीक है? Yes. Any other question? Shall we move? Okay. Next is minority status for the institutions. Minority status, the only thing here that is in current news is educational trust in society seeking minority status now required to be registered as NGOs, that is non-governmental organization with the Niti Aayog. So if you want to acquire the minority status for the institution, you have to register yourself as NGO under Niti Aayog, whether they are seeking the government aid or not. So irrespective of the fact that whether aid is there or not there, you have to get registered. Rest of all the provisions are nothing but there's fundamental rights 14, 15, 16 and 25, 26, 27, 28. These are all. And the last is that 350B. We have discussed that. So these are nothing but the all provisions. What is 350A? Yesterday I have spoken. 350A kya tha? Mother tongue at primary level. 350B is a special officer. Yes, President will appoint the special officer for the minority, linguistic minority. And 351 is a Hindi language, promotion of Hindi language. Okay. Social audit. Social audit is more of a concept, but just if you want to remember, here only one thing is that Meghalaya has become the first state to give the legislative backing to the social audit. That's the only thing which you have to remember. Nothing else. Just I'm giving in 1 minute idea of what is conventional audit and the social audit. The conventional audit is done by the government agencies. Okay. So it's a whatever the program they are implementing, parallelly there exists the audit mechanism also. Okay, that is by the government agencies. And generally, these audits are more of on the basis of economic parameters. Okay, so whatever the fund, say for example, 500 crores here is released at state level, 50 crore, 5 crore, 5 lakh. So they are going to cross-check whatever the outlay is there, whether it is being spent or not. So it is more of a financial audit. Financial criteria is used and by the government agencies. Now the social audit is a new concept where we see the audit is done by, yes, by whom? Yes, by beneficiaries. The better word is all the stakeholders of program, okay, or scheme. So they are stakeholders, the most important stakeholder is beneficiaries, or directly by the people, or by the society. So although the beneficiaries is going to be the most important one, but there will be also the NGOs who will be assisting these beneficiaries, or one or more government agencies also who will be facilitating the process. But primarily, it is by those for whom the scheme has been devised. So naturally, the advantage that we see here is there is a chance of here conflict of interest here, because you are, so obviously it is more of a formal exercise rather than very effective exercise. Now here, if the beneficiary themselves are going to cross-check, so it will be a more transparent and effective mechanism. So generally, it is done by this Gram Sabha. At Gram Sabha level, we are trying to create an institutionalized mechanism where the people of the Gram Sabha will come and do the auditing. That is called social auditing. And it is, although obviously the financial component is there or economic component, but apart from economic component, it will be tested against the social parameters also. Social parameters like, say, for example, here, let's take an example of health or education. So here, they will only see that whether the 5 lakh has been spent or not. Here, they might see what is the literacy rate, what has been the reduction in the gender gap, okay, or in case of health parameters, what has been the reduction in the IMR, MMR, quality of life, etc., etc. So social parameters. So in that context, you see that this is very effective auditing. But for this, the limitation is there is no legal backing for social audit as of now. Okay, it is more good to do exercise. Okay, and therefore, because it is good to do exercise, so most of the times it is not there. Okay, it is not well institutionalized. And second thing is because it is to be done by the beneficiaries and the common man, so there are lack of expertise also. Unless and until there are good NGOs which takes the initiative or the government provides some initiatives in the finances, we do not see the effective social auditing. There is one act where there is a legal backing. You have to do the auditing through the social audit only. Which is the act? NREGA, yes. NREGA की auditing social audit के through होती है. So if you read this Yojana Kurukshetra, you will invariably come across this point that in NREGA there is a legislative, that is a statutory obligation that the money that is being spent in NREGA, that has to be compulsorily audited by social audit. Except that program, it's more of a good to do exercise. Now in this context, we are saying that Meghalaya has become the first state in India to operationalize the social audit law. So they are trying to give the statutory backing to this, the Meghalaya Community Participation and the Public Services Social Audit Act. I hope that much point is enough, okay? So let's move on. Rest of the points are the same. What is social audit and importance, etc. You can infer from this only, okay, what are the advantages, disadvantages. Next is project monitoring group. Okay, this is again the old news, that is 2013 under the cabinet secretary, and presently it is functioning under the PMO. So name itself is saying that project monitoring group. So it is fast tracking of approval of splitting the expeditious commissioning of the large public, private and the PPP projects. Okay. Nothing much here. Just remember that that Pragati platform, okay, that is more very much in the news. That is PMO, cabinet secretaries, and secretaries at the state level. So that platform is important. Public Affairs Index. Public Affairs Index is related to ranking in terms of governance, physical, and the social infrastructure. These are the rankings of states. Public Affairs Center. This is a non-profit think tank, Bangalore. See, this time, many times we are seeing the questions of this nature. This report, and this report is released by which organization or which entity. So whenever, if there are more popular report, you should remember that which organization is coming up with the report. So here, this Public Affairs Index report, or these indices, this has started in 2016 by the Public Affairs Center India, and Public Affairs, its headquarters is in Bangalore, non-profit organization. So the Indian states have been classified on the basis of ranks. The broadly 3 parameters: governance, physical infrastructure, and the social infrastructure. Kerala and Tamil Nadu are reading. Nothing much there to discuss. Corruption Perception Index. This is important. I mean, again, are asked. So it is by the Transparency International. And the Transparency International location is Berlin, Germany. And Transparency International also comes up with the one report also. That is Global Corruption Barometer. So 4 things you can remember. The one is the name, that is Transparency International, location, that is Berlin. Second is Corruption Perception Index, and fourth is Global Corruption Barometer. Okay. So these are 3, 4 things you can remember. Rest of the things, ranking and all, generally is not asked. Okay. What is the ranking? It is the 81st for the India. 80, 81th. And this year's theme was, they are, if at all, if they can, they are interested. The theme this year was, or the focus of attention was, relation between the corruption and the freedom of press, association, and expression. This particularly Article 19, that how much the press freedom, association, particularly NGO freedom, and the freedom of speech and expression. So they have found they have found this, that wherever there is a less freedom for the press, association, and expression, there is a more corruption. So that's the association. So the focus of attention of this year was on finding wherever the freedom of press, association, and expression are curbed, and what is their corruption ranking. Okay. The next is COMIT, Comprehensive Online Modified Module on Induction Training. Just remember, because they might ask you this word COMIT, and it is related to. It is related to the training program of state government officials. That's it. Nothing much is required to be known. That COMIT is some sort of online training program for the state government officials. Yes. Huh. Religious community. See, the thing is, religious communities are already been, see, there is nothing new as such comes. Their institutions are religious. We have, see, the only new addition was Jain. Acha, the protest that is there, okay, they are saying. First, they have to come as their religion, and after religion, they will be the minority ones. Okay. Now there is a debate, like Lingayat says that it's a part of the Hindu and it's a caste only. Now they are claiming that we are not the caste, we are altogether a separate religion. How center will go, obviously the matter, I don't know how the religious minorities are to be determined. Does anybody has any idea how the, No, that is a recommendatory body. He's saying that how the process goes into that. Obviously, there will be a recommendation. Recommendation based upon number, basically, what they are going to look into. Because see, there are no religion except this 5 that we are known, and they are not minority. So whatever except Hindu, which are there, they are recognized as minority. Although the Jain was the latest addition. Okay. And now the thing with regard to, yes, please. Hmm. Hmm. Okay. Hmm. Jainism. Okay. Religion. Lingayat come under scheduled caste? Yes. Okay, some. Okay. Okay. If what was the last point? If somebody is not a part of? Caste reserve. You are saying, do they deserve to be a religion or not? Means you are saying that there can be only one religion. No, no, no. I got your point. I got your point. Yes. So that's the answer. Okay. That Home Ministry, but Home Ministry will ask to pass the law, Parliament. Okay. Yes. Fair enough. So that's how it goes. But yes, the most important first is whether they are minority or not. First point is whether they are religion or not. So that point has to be settled first. And as he has said, if there are going to be this ramification of not getting the benefits, then again some of the sections within the community is going to, or maybe they will be shifted to another religion. It's not like scheduled caste people are only for the from the Hinduism. Scheduled caste. Uh, Outcast. Okay. Okay, let's move on to the next where we stopped. Okay, comment is over. Next is we have to now speed up the things. Municipal bond. Municipal bond is a little important thing. I'll just discuss briefly because if you see the urban local bodies, this has been much in the news, that financing of urban local bodies. So one of the mechanisms that has been proposed is through the municipal bond. Now this municipal bond will will be flouted obviously by the municipal corporations, and this is a mechanism of investment, okay, or fund mobilization. So with this bond, the SEBI has come up with certain guidelines and certain things that what are the criteria, advantages, disadvantages to be different stakeholders. So you must know because they might ask you what are the things as per the SEBI's guideline are right. So following 4 or 5 statements and what are the things said by the SEBI. So the first thing you see all the municipal corporations will not be able to float the municipal bond. There are certain conditions. So first condition is with respect to the investment grade rating of that municipal corporation. Okay, so there should be an investment grade rating. Recently, there has been a rating of some 99. How many cities? 94 cities. And out of 94 cities, 55 of the cities have got investment grade rating. Investment grade rating means your municipal corporation has a good financial strength that you can invest into this municipal corporation. If obviously there is a sick municipal corporation, fiscal discipline is not there, so obviously it will not come under the investment grade rating. So the first thing is investment grade rating. Second is whatever the investment is there, say for example 100 crores of investment, so 20% of the investment must be by the municipal corporation only. 20% of the total investment should be by the municipal corporation. This is obviously to share the risk, to increase the confidence of the investors, that if the corporation itself is investing into some project, so it will increase the confidence also and the risk sharing also. So these are, the third thing is they must not be the defaulter of any loan, okay, in last one particular year. It again related with the fiscal prudence, that you have not defaulted on any loan. Fourth thing is, whatever the investment that you are taking, so you should have the cover in order to give back the investment. So the principal amount that you collect for the investment, that much of cover municipal corporation should have. Why? Tomorrow, if anything happens wrong, so you should have a capacity to repay back. So the cover for the principal amount. So these are some of the 4 things which are required. Then and then you are qualified to issue the municipal bond. These are the guidelines of SEBI. I'll just repeat that. One is the investment grade rating. Okay, currently only 55 cities have the investment grade rating. Second is whatever the investment is there, out of which 20% investment should come from the municipal corporation itself. They should not be the defaulter of loan in last 1 year, and they should have sufficient money to cover the principal amount of the investors. Now, what are the advantages for the one public who is doing the investment into the municipal bond? The first one is it is a tax-free. So whatever the investment you are going to make, so there will not be a tax. So that's a sort of incentive for the public, and that is a government policy so that the urban local bodies will get the fund. And second incentive is that the interest of, these are not interest-free bond, zero coupon bond. There will be an interest, and these interests are linked to the market. Okay, so whatever the market rates are there, so it's quite high. It's not like only 5%, 2%, whatever the market rate. So the interest on the bond, interest rate of the bond is related with, is linked to the market rates. This fund generally will be invested for the physical infrastructure, for the development of the urban bodies. You have these different schemes like smart city and what are the things for the different schemes? Huh? Hriday, Prasad, yeah. One more is there. Amrut, okay. Hriday, Prasad, Amrut. मंदिर में जाके नाम याद रखना है सिटी के नाम है ठीक है yes these are different sorts of smart cities and this thing so you require a huge funding this is one of the mechanisms so you remember these 6 points 1 2 3 4 and these 2 6 and municipal rating and this rating as Crisil has already given the rating so this is important thing because Niti Aayog has also spoken about this thing Ministry of Urban Development has also so time and again you will see that municipal bonds are one of the going to be an important instrument although it is very difficult to see that whether the people, how market is going to respond because the gestation period of this is too high for the projects. So whenever the return comes, second thing is the government bond is essentially a government bond. So there is already no faith with respect to the investing into the government financial instruments. So we have to see that how the government is responding. There is also, although here it is not mentioned, another new way of instrument is that is value capture financing. Okay, second is, here it is I think not mentioned. That's also a very new concept, I think in 2017 only it came. Anybody has heard of this? What is value capture financing? Yes. 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 What do you want to say? See, the thing is, there's a very interesting thing. Say, for example, government come up with lot many different infrastructure projects. Okay. Say, for example, they come up with the airport, railway, bullet train. Okay. Now, when it passes through area, say, for example, airport hai ya bullet train hai, so what we see is the value of the land goes on increasing. Okay. Skyrocketing prices overnight. Because the infrastructure, okay, very important, like airport, bullet train, or any other, which is very industrial area, SEZ. So whatever the projects, this is coming up with the government. So incidental to that, the common people or the developers which are in and around the area, the land prices are getting rise like anything, and therefore they are getting benefited out of it. Now what the government is saying that why not to capture the tax out of that? And we have to force them, because you are getting benefited, you have to pay certain tax or fee, any kind of, not tax, there can be different ways. Value capture financing is the value that has been increased because of the infrastructure development of the government. That value has to be captured and should be used for the financing. That is the concept of value capture financing. Now, there are various devices within the value capture financing. There can be a land tax. Okay, the land which is whose price has risen, so you can put a land tax. There can be a fees for differential land use, change in land use, and therefore you are taking the fees. There is there is one word called betterment tax. So betterment tax is what I have explained. Betterment is benefits that have been increased. Okay, that leads to the betterment of the public. So there is a betterment tax because of airport and bullet train and etc. Your value has increased, which has led to the betterment of you. So you have to pay the tax on that. So there can be various names. That name are not important, but this has come up as a very important instrument for financing. So they will collect the finances from the people who are getting benefited, and they are going to invest in the further infrastructure development. Okay, so that is about the value capture financing. Okay, so that's these are two important ones because they are very much in the news. Next is the training elected women representatives of the PRIs. This just remember this a Ministry of women and child development, because there can be a confusion. There can be a confusion where Panchayati Raj Ministry or maybe the Rural Development Ministry, but it is the Women and Child Welfare who are going for the empowerment of the women of the Panchayati Raj. Nothing much to discuss there. Steps taken by political participation of the women. You must be knowing these are the some of the 73rd, 74th, one-third of the seats. 108, which is pending. Okay, that is the bill which is pending in where? Lok Sabha. Okay, next. Constitutional, regulatory, and other bodies. Niti Aayog, you must have read everything about Niti Aayog. Just what has been mentioned here is that document, 5-year plan national development. That's wrong, I think. 5-year plan national development agenda. How come? There is no, the 5 is very sensitive. There is no 5-year plan. They have, in fact, done away with the, yes, 3-year plan is there. So there is, no, here the headline is 3 likha hai. No, here the photograph is there, no? 5-year national development agenda. See, you have the 3, 7, and 15. The only missing word is 5. Okay, so Niti Aayog has come up with the one, what they are calling as a vision, strategy, and action. Strategy and action. So action is of within 3 years. The strategy, 7 years. And this is 15-year document. Everything starts with 2017. So this is 2017 to 31. 2017 to 24. And 2017 to 19 or 20? 20, okay. So these are this is a broader vision. Now they are saying that we will combine the long-term vision, the state as well as the national policy. So that's a broader vision. Out of that vision, some strategy will come and then the action will come. So this is a broader long-term plan. 3 years, 5 years, nothing much now. There are certain initiatives which you all must be aware that competitive federalism, that's the words which is very popular. So they are coming up with many indices, okay, in order to create a competition. So some of the indices, farmer-friendly reform index, state performance, health outcome index, school education quality index, water management index. I think with this Swachhata Abhiyan index is also there, some Sarveksham. What is? Swachhata Sarveksham. Okay, so these are some of the things. About the NGO Darpan. NGO Darpan is nothing but this is a platform offered by Niti Aayog, and it was developed in the association with the National Informatics Centers, MITI. It is to bring the greater participation between the government and voluntary organizations. That's the only one line you have to remember. NGO Darpan is the synergy between the NGO and government organization. So that's a common platform, that's it. And there will be obviously unique ID for the NGOs, and that is how the communication will be done. Next is the Lokpal. Lokpal, what is to be discussed? Recently, the Supreme Court has made it clear that existing Lokpal and Lokayukta Act 2013 is workable in the present form. So there is nothing as such to be discussed in current, because it's just because we have seen that leader of opposition was the controversy. Leader of opposition, because the appointment of the Lokpal members, okay, will be by the committee, and that this is a 5-member committee, select committee. So the 5-member select committee will have one of the member as a leader of opposition. Okay, just giving the overview that what is the composition, 1 plus maximum 8. Okay, total 9. Total maximum can be 9. That is a 1 chairperson and maximum 8 other members. Lokpal. Okay, some of the things you should remember. Second is within that composition, 50% people should have from the judicial background. judicial acumen. Okay. Then out of this members, 50% should come from this, there is a quota. So they might come from SC, ST, OBC, minority, and women. SC side हो गया क्या? 50, 50, 100%? Is that right? Huh? So how many of thinking, okay, 50% judicial background, 50 this. It's nothing of that sort. There can be judicial people from this background. Okay, it's independent. So whatever the number, 50% will be from this background, and 50% should have a judicial acumen. Okay, so there's nothing like, don't ignore CSAT. Lot many people flunk in CSAT. Okay, so try and practice at least 2-3 papers, particularly. Okay, don't take it for granted. Yes, so that's the composition. Now, to go for it, there is a select committee. Select committee has 5 members. It has a prime minister, leader of opposition, speaker, and CGI or any other person appointed by him, the judicial figure. And the last one is any eminent person. Eminent person, and this eminent person himself is nominated by the 4 of them. Okay, these are the 5 members. Prime Minister, Leader of Opposition, Speaker, CGI or any other highest member of Supreme Court appointed by CGI. And last is eminent person. This eminent person is appointed by the rest of the 4. This is a 5-member select committee. Now, this government was saying that obviously we are not appointing we are very serious about the Lokpal, but there is no leader of opposition. That's why we are not able to. Okay. And we cannot bring the ordinance here because it's a very sensitive matter, so Parliament should take the due action. Anyway, so the Supreme Court has said that leader of opposition, you can go ahead with the appointing the Lokpal. Okay, so the leader of opposition, it's not a big thing. If you see the other thing like CBI and CVC and etc., where they have already changed it into the leader of the largest party, okay, opposition party. So obviously we see that it is more a lack of political will, okay, rather than these are all. But this is the technical point, okay, that you should remember. Rest of the things is select committee jurisdiction of Lokpal. You should remember 3 at least prominent jurisdiction. One is the political members, that is MPs and MLAs, including Prime Minister. Although the some of the aspects of the Prime Minister are not included, but Prime Minister is there. This was a controversial initially whether the Prime Minister should be included under the Lokpal or not, but it is, yes, it is there. So MPs and MLAs, that is a political class, both executive as well as the legislature. Second important thing is higher bureaucracy. Okay, higher bureaucracy. For the lower bureaucracy, which is the investigating body, for the corruption, CVC. So the group A, group B, so higher bureaucracy. And the third one, which is interesting one, the NGOs or any body which is receiving the foreign fund. Foreign fund which is receiving more than 10 lakh per annum. So any NGO or any entity which is receiving the foreign fund more than 10 lakh per annum will be also under the Lokpal. Because the Lokpal was being asked by the NGOs and India against corruption and etc. So if you are dragging us, we will also drag you. Okay. So if you see, the Lokpal is basically the government funding which was there. Earlier CBC mein, so that's why it is called as the big ticket corruption. The cases will be of big ticket corruption. So these are the general mandate of the Lokpal. The lower bureaucracy is still in the hands of the CBC. Although the Lokpal will have the power of superintendence on the CBC cases which will be passing through the CBC. So this is the point important. Jurisdiction we have already done now. Power with respect to the CBI. See, the CBI completely is not under the purview of Lokpal, completely. But whenever the case of corruption will be handled to the CBI officers, so those CBI officers will be under the control of Lokpal. So their transfer at that particular time will be under the Lokpal. And the last is the attachment of property. They have this power even before the prosecution. Like generally what happens when the prosecution is completed and person is convicted, there is attachment of property. So here, confiscation of property is acquired by the corrupt means even while the prosecution is pending. Where is this power? One more act is there which is very popular. Internal security or IR mein pada hoga. The attachment of property. This word comes every day. Money Laundering Act. Okay, Prevention of Money Laundering Act, where obviously the attachment of property, but most of the times the attachment of the property, we don't have the data, and most of the times the attachment, the property is outside the country. Lalit Modi, Nirav Modi, or lot many people. Malia. So where to attach the property, how much to attach, so all those questions are there. But yes, Money Laundering Act, there is a tremendous power, okay, to the tax officer. So here also we have seen that provision. And the last also, the Act lays down the clear timeline for the preliminary inquiry, investigation, and trial. So to expedite the process of corruption, so there is a time limit, okay, which has been mentioned here, although the time limit has not given. But yes, I think it is in matter of 3 years, the cases has to be resolved. Otherwise, we have seen this Jayalalitha's case, it took almost 2 decades, okay. So these are some of the provisions you should remember, rest of the things are not required. Finance Commission, a new 15th Finance Commission has been constituted, that is NK Singh Commission, and supposed to give the report 2019. I'm not discussing provisions, constitutional provisions. CVC again, why it is in the news? Because the bank, RBI has given the approval that CVC can probe into the private banks' employees also. So why this was important? Because Prevention of Corruption Act says that public, there is what is called public officials. So whether the employees of the private banks are the part of public officials or not, that was the question. But now the matter has been resolved. They will be taken as a public official. So public employees working in private banks, so they will come. Rest of the things are about CVC only. So again, you can refer to Lakshmikant and see what is CVC and etc. National Green Tribunal. Okay, here there are 2-3 things you should remember, because this is again very much in the news, and this is a tribunal which has settled lot many issues related with environment. Shri ji, kya naam hai unka? Ravi Shankar. So quite in the news, and because of other things also. So you must know some of the basic aspects of National Green Tribunal. So why it was it in the news? Supreme Court has stopped the implementation of notification of central that allowed the chairperson of NGO to constitute single-member bench in exceptional circumstances. They were going for, because of lack of or paucity of human resource, they were going for the single bench. So Supreme Court has said that single bench should not be there. Okay, that's the news, but we will see what is NJT, some of the basic things. So NJT, when it was established, 2010 Act. Now, we have already discussed some of the aspects of tribunals. Okay, so it is one of the tribunals which is on the specific matter, and the specific matter here is environment. So the composition here, again, there are certain legal or judicial people, and there should be certain non-legal or non-judicial people. Non-judicial. So judicial people who will be there, that is retired or the acting, that is existing judge of the High Court or the Supreme Court. It written only, so it means that it has to be a Supreme Court or the High Court, retired or present judge. Non-judicial member, he should have an expert on the environment, at least for the 15 years. So that's the composition. Second thing is, remember that it's a quasi-judiciary body, and one of the important principles that they work on the principle of natural justice. So sometimes they go beyond the technicalities of the law also. What is the principle of natural justice means? It's not just about the technicalities of law. There may be an humanitarian angle, there may be some other angle. Okay, so likewise they can interpret. So they go for this interpretation. Next is the matter has to be disposed within the 6 months. So timeline is also there. We have just discussed that tribunal is for the expedition of the process also. You should also remember there are one principal bench and four regional benches. So principal bench is in New Delhi and the regional bench is in Pune, Bhopal, Chennai and Kolkata. Okay, there are 5 benches. Power and the matters that they draw is from these 4-5 acts: Water Act, Air Act, Environment Act, Public Liability Insurance Act, Forest Act, Biodiversity Act, obviously related with the environment. And remember, the appeals from the NJT will lie directly to the Supreme Court. They may took it as a divisional bench of the High Court. So it's not, we have just now seen that in case of tribunals, administrative tribunals, the matter will go to the divisional bench of High Court. So here the matter will directly go to the Supreme Court. So these are some of the points you should know because it is many times in the news. Autonomous bodies. Autonomous bodies, see there are 2 autonomous bodies. Why it is in the news? Because 2 autonomous bodies to be scrapped, I think, proposal to close, yes. And this Ratan Vattal committee submitted the report on review of autonomous. Why I'm feeling this committee is related with some other also. Yes, digital payment, Ratan Vattal committee, I think. Yes, NPCI, what? National Payment Gateway. Okay, yes, that is also there. Autonomous bodies. Or Ratan Vattal committee is also there for the digital payment. Okay, they have suggested lot many reforms there also. So what are the autonomous bodies? The name itself is, these are the bodies of government, but they enjoy a lot of autonomy in their functioning. But obviously no institution in India is completely autonomous. Government does control them. And in this context, this committee has suggested some of the reforms for the functioning. And there are 2 bodies which are to be scrapped or closed. The last box, that is the Rashtriya Arogya Nidhi and the Jan Shiksha Sthirta Kosh. Okay, so this Rashtriya Arogya Nidhi, this was the fund actually. Nidhi is a fund. So this fund was to help the people from downtrodden in order to get treatment in the government hospital. So financial support for the downtrodden to get the treatment. That is Rashtriya Arogya Kosh. And next one was the Janashakshas, Janasankhya Sthirta Kosh, Population Stabilization Fund. Okay. It was to create awareness, that's also closed. Amendment to Whistleblower Act. This is also important because much of the times this discussed. It is already there, it has not been enacted again, Whistleblower Act. It was enacted, okay, 2014. Year is given or not? Okay, the last session of UPA government they have enacted. But we have seen that as of now there has not been rules for implementation. And the current government has in fact come up with the amendments. Amendments, they have thought that this Whistleblower Act is too strong, okay, or too weak maybe. So we should reform it before even implementation. So we will see that what are the amendments that has been proposed. First of all, if you see this Whistleblower Protection Act, here which authority will take the complaints if you are a whistleblower? Okay, SEBI, no, SEBI not. Why SEBI? How come you brought in SEBI here? DOPT, okay, or concerned department. Anything else? Yes, the word used is competent authority. You know, maybe बहुत diplomatically covered. Disclosure to the competent. Who is the competent authority? Yes, CVC and SVC. Okay. CVC and SVC. So obviously, if the cases are related with the state government, it will go to the state vigilance. And if they are related with the central government. Second thing is, do you need to give your identity? Or anonymous complaint can be entertained? Yes, identity is must, okay? So while giving the disclosure of anything, you must disclose your identity. Without identity, it will not be entertained. No matter whatever foolproof evidences you are going to send, okay? And if your identity is not there, so obviously it will be put into the dustbin, okay? Why identity is required then? A very curious question. If you are very serious about corruption, you should be serious about the matter which is sent to you. whether there is a merit into the matter that is sent or not. Frivolous complaints. Okay. So if the frivolous complaints will be find out, don't you think that it will increase the deterrence? Okay. Okay. Yes. So that is where they say that identity is being taken. But think of if you are exposing something, your identity will be. We have the cases of this Satyendra Dubey, okay, Manjunath. Have you heard of this name, Manjunath? IUCL, yes. Vyapam. Okay, how many people? Even their names are not there. Okay. Anyway, so identity has to be there. Next thing is, what they are saying is, identity will not be disclosed. Okay, what is the protection that is given is, identity will not be disclosed, but you must be given the identity unless in very exceptional circumstances. And the last one is, if there are frivolous complaints, there will be an punishment. If frivolous complaints will be fined, there will be. There are a lot many, we say that riders, okay, it's not that easy as per the Whistleblowing Act. This was the original act I'm discussing. This was the original act that that was there. And what you can disclose is there was all sort of corruption or any criminal thing. So anything which is detrimental to the system, working of system, you could have disclosed. This was the original act. Now there are proposing the amendments. Okay, so first amendment is the amendment will seeks to remove the immunity provided to the whistleblower from the persecution under the Draconian Official Secret Act for the disclosure made under the Whistleblower Protection Act, offense punishable under imprisonment. See that simple, to put simply, there is an Official Secret Act. And Official Secret Act, there are certain secret things which should not be exposed. Okay, that is what the Official Secret Act is about. Okay, it was again not only a draconian, but it was a colonial hangover, because basically Official Secret Act has no role when the RTI Act has came into being. So RTI is contrary. RTI already mentioned Section 8, through which it protects whatever the sensitive things which is required not to be disclosed. All of you are understanding? RTI has that mechanism. Section 8 is all about that everything and anything cannot be given into the public domain. The Section 8 is to protect that. Now, still the Official Secret Act has been mentioned. Now, the point is, Official Secret Act has a draconian provision that if the matter which will be a very sensitive, he will be provided the 14 years of punishment. Now, initially, this whistleblower would not have invited this provision. He was immune from this provision. Now, there is a danger that you might expose something and you might invite the violation of the Official Secret Act, through which you will get the 14 years of punishment. So something written here, for frivolous complaint, there will be a punishment. This punishment is, I think, very less, some 2 years or something. But now, if something will fall a sensitive matter under official secret, so it might be up to the 14 years. So this is one layer that has been added. So immunity which was there to the whistleblower from the Official Secret Act, it is no more there, or it is. Second thing is the scope. Bring the Whistleblowing Act with the RTA. Complaint by the whistleblower containing information which would prejudicially affect the sovereignty, integrity, security, economic interest shall not be inquired into. So if you are coming up with any information which jeopardize this aspect, now these are very vague words: sovereignty, integrity, security, economic interest, etc. It means that again it is curtailing the scope of whistleblower. Have you understood this point or not? So they have said that if any information which is detrimental to this, then that information will not be looked into or inquired into. So even if you expose something and they feel that CVC and SVC, that this matter is a sensitive matter for the country, so it will not be investigated. So if the defense matter is there, it is too sensitive that it should not be investigated, quite possible. Understood or not? Okay, next is, in addition, certain categories of information cannot form the part of disclosure. Initially, the definition of disclosure was very liberal. Now they are saying that there are certain categories of information which will not be a part of disclosure. What are these? See, already we have seen that something matter which is sensitive to national interest. But apart from that, there are certain other things also, such as commercial confidence, trade secrets, which will harm the competitive position of the third party related with IPR violations, contract torts, etc., etc. So financial matters. Then the question remains, what is remain to be exposed? That's where the UPSC also asked the question 2 years back. If the current whistleblowing amendment will be passed in the parliament, there will be nobody left to blow the whistle. Explain. Okay, this was in Polity paper. If you have seen 2 years back, this was the question. Because if you see all these parameters, then nobody will be there. Okay. Anyway, so that's the main. So these are three categories included in the information related to economic and scientific interest. Cabinet proceedings also you cannot expose, and intellectual property and matter, which is of fiduciary capacity. What is fiduciary capacity? Fiduciary is contractual interest. So those things cannot be exposed. Next is IIIT, Information Technology, Indian Institute of Information Technology, Bill 2017. Just one line, these are the new institutes to be created, or some of them have been already been created. This will be recognized as institution of national importance. That is it. But you should know that what are the institution of national importance. So these are some of the, again, 1 or 2 points. This has to be established by the Act of Parliament, one. Second is, these institutions are created to impart the high-skilled, developing the highly skilled personnel with specific region of the country. And third is, it is usually supported by the government, or there will be a support from the international institutions also. So these are the 3 points. So Act of Parliament and the Center of Excellence, or developing the high-skilled personnel, and third is government as well as international. So these are the institutions of national importance, and new addition is Indian Institute of Information Technologies. Anti-torture legislation, there is nothing to explain here except for the one line that Law Commission has stated that India should come up with the anti-torture law. Okay, and we have already been signatory to this convention, United Nations Convention Against Torture. We are signatory, but we have not ratified it. Okay, so there has been a pressure that we should come up with the standalone act. Okay, one particular dedicated act has to be there on the torture. Okay, but there are difficult provisions, so therefore India see the Prevention of Torture Bill 2017, wide definition of torture. Torture is not just the physical, but it is also the inflicting the injury either intentionally, involuntarily, and even attempt to cause such injury which will include physical, mental, and psychological. So it's a quite a wider definition. Like Domestic Violence Act, you must have come up with these words. Okay, when you will do the society, you will get to know, okay. This, sovereign immunity not for the agent of the state. So generally state hide itself that they have the power of law, they are the law implementers, etc., etc. But if the state is also committing the atrocities, so they will also come under the purview of this anti-torture. Punishment for torture for the public officers, public official for inflicting. So these are some of the provisions. Again, that's the bill. National Medical Commission Bill. Now, some of the provisions, last point are the key features of the bill. We don't have to go into the background and history. One is, ये पता ही होगा बहुत news में है, National Medical Commission. It is going to replace the MCIM. Medical Council of India will be replaced by National Medical Commission. The same will be there at the state level, which will be known as state medical councils. And there will be a medical advisory council, which will be a common platform for the state and the union territories to express their views to the NMC. So it's a connecting link between the state medical councils and the NMC. So state medical councils will, there will be a common platform to deliberate. Final authority is NMC. So these are the three institutional bodies you should remember. And apart from that, there are certain related with the functioning of NMC. Under that, 4 autonomous boards: undergraduate medical examination, postgraduate medical examination, medical assessment and the rating. Okay, there's colleges rating and etc. And ethics and medical registration board. What is this ethics and medical registration? Hmm? Yes, the unscrupulous practices which are there in the yes. So in order to curb those unscrupulous practices, unregistered practices. Yes, yes, please. Nominated. Is it so? All, every time. Public administration, okay. Person can tell you. I- Acha. Just check it because I'm not very sure that how it is. See, the thing is, yesterday only I was reading some 7 amendments also they have proposed. So there's not a final draft. Okay. Yeah, particularly this mm, medical bill. Yeah, on general terms, you are right that council is there, but I don't know it's a hard and fast rule or not. You are right in that sense that councils are generally the bodies, the members are elected. But you see that all the members are not always elected. That municipal council, there are nominated members also, 4/5 and 1/5, 2/3 and 3/4, and likewise. So it's not a completely always an elected body. Okay. Yes, next is the NEET exam that will be conducted. Uniform exam will be there. Then national license set examination for the license of practice and the admission into bridge course. I think this was dropped recently, so you can make a cross. Ease of regulation. Medical college needs a permission only once. Yes, this is a little controversial because on one side you are talking about this ethical and medical registration board, but then they are saying that only once recognition is required with no need of annual renewal, and colleges also can increase the number of undergraduate seats and the start postgraduate program by their own. And this will open the Pandora's box because how they're going to go with the opening of postgraduate and graduate. So that's it. Anyways, that's analysis is not important, but just keep updated because cabinet has approved some 7 amendments. Okay, and again they are going to review. So that's still a matter which is pending. Final word has to come. Anti-Hijacking Act. Okay, this is in 2016 it came into force. Just remember this Beijing Protocol is there for the International Civil Aviation Organization with respect to the protection of civil aviations. So in that context, we have developed this act. This is in order to protect the civil aviation and the passengers which are flying through this. The most important provision here is to an extent of capital punishment. Okay, the thing is there. Capital punishment in the event of death of any person, including the ground staff also. Okay, so the capital punishment. Second is the definition of hijacking is quite broad. It's not you should have hijacked the plane. Okay, attempt to hijack, attempt or abatement. Abatement is direct or indirect support. Making a credible threat to the commit the hijacking. Credible threat we have, that is also organizing and directing the others to commit the hijacking. So indirectly also if you are involved, agreeing with another to commit the offense or acting on the agreement. So any kind of direct or indirect your participation can invite you the punishment, and the maximum punishment that we see is the capital punishment in case of death of the law enforces the concerned security forces to immobilize the aircraft and prevent the takeoff. Indian Air Force has a power that they can force the plane to land, and they can even shot down the hostile plane. So these are all, if you can visualize hijacking, so you can easily understand either to force the flight to the ground, shot down the enemy, and protect the people and punish them. As simple as that. Okay. But we are not Israel, okay? So that's very difficult. What is there in text and what is there in practice? Have you seen the Operation Entebbe? Hmm? Operation Entebbe. It was a brilliant operation. If you see the operation, yeah, Israel has conducted, obviously. So, yes, anybody has any information? क्या था Operation Entebbe? Yes, it was in the during that Palestine and this controversies were there. Not Yemen, it was a Congo, I think, African country. Yes, there was a dictator. I'll, Mossad, obviously, Mossad were there. See, I'll explain in one or 2 minutes. It's interesting. कभी बोर हो गया तो YouTube में डाल के देखो. You will feel very thrilled. It is better than any Hollywood picture. You will amazed that something like this has also happened. Okay, in reality. Yeah, Benjamin Netanyahu's brother. Okay, yes, brother was there. He died. So it was a plane which was hijacked. I think the France plane was there, and most of the passengers were European passengers as well as certain Jews passengers were there. So the flight was being taken from the Europe, and it was landed somewhere in Congo, and there was a dictator who was in connivance with this, yes, Arabian countries. So Palestine, basically the Palestine and this, they have captured the plane. So the plane was landed in this African country under the demagogue, and it was kept there. So they called up obviously to release the Palestinian, yes, those should we call terrorists or freedom fighters, okay, to release them because and if they will not release, obviously they will shoot down the people. So the Israel government has said that okay, no, give us a 1 day and we will make arrangement. So they said that okay, 1 day is given to you. So in 1 day, what they have done is they started planning now to go to the Africa and airlift them. So 1 day was not enough. 1 day went, and then second day came, and then again they said that no, no, last 24 hours you should give it to us. So in that, what they have done is they have segregated the people, those who are from the France citizens and etc. They are separated, and those who were Jews from the Israel they have separated. So some 150 people of Jews were separated into the corner, and rest of them were released. Okay, because there was international pressure also on the Arab countries why European people are being captured if you have the enemy Israel. So when the France people came back, this Israel intelligence agency Mossad went to those released people and they made the map and they identified how the room is, how many people are standing, where they are lying, what is the position, how they are taken. Everything has been done. And in the night, they have airlifted. Now, there was a possibility that it will get detected by the radar. So they have literally, the Red Sea was there. So 100 meters above the sea, the aircraft was flying. And the driver has no signal whatsoever, where to land, how to land, no light, no electricity, no signal. It was just the flight, he has to land by chance. And the first land will come and they will go and do the operation. So there will be only the military agencies in that. Second aeroplane will followed by, and after 15 minutes operation, the 15 minutes later, the second flight will come, and the rescued people will be taken to the second flight. Now the point was, it was an international airport of that Africa. And even if you will land, how will you come out of the airport? That becomes again an interesting question. So they got to know that the president used limousine or something. So they arranged one duplicate limousine, okay, there. So, and they started wearing all those security guards' clothings and all. So they sat, they came, they entered where hostages were kept. They rescued everyone. The second craft reached. They put them, and they went back. And in the BBC, it was declared in the midnight that they have been rescued. Out of 150, I think only 2 people died, 2 or 3 people died. 140, हाँ वो भी confusion में. Actually हुआ क्या था कि they were given the operation. They started talking in Hebrew, okay, that we have arrived and don't worry and etc. So in an excitement, he jumped. And it was, the information was whoever is standing, they are the one who are enemies. So because he started jumping and he stood up, so he faced the bullet and he died. Rest of the people were rescued. So that's the Israel. The point is only making the law is not sufficient. You have to develop a lot of capacity also. Okay, anyways, next is 15 minutes are remaining. How many pages are there? Okay, this is simple ones. There is national policies. First one is the National Sports Talent Portal. Ministry of Youth and Sports. So this is a portal basically because we have seen that our performance in Olympic is not very good. So in that, to tap the talent of the rural youth, okay, we have launched one portal that is called as the National Sports Talent Search Portal. So this is launched by the Ministry of Youth Affairs and the Sports, and through that, through online, they can you can that through the portal. Obviously, there will be a connecting link in between the talent and the people who are hunting for it. That is the government. So that's the portal. Nothing much here. Next is the Khelo India. Khelo India is now a broader umbrella name given to all the schemes which were existing prior to it. That is Khelo India National Program for Development of Sports. So it has actually subsumed the three different schemes which were existing earlier into one. One is the Rajiv Gandhi Khel Abhiyan. Second is the Urban Sports Infrastructure Scheme. And third is Sports Talent Search Scheme. So one is with regard to training, one is regard to the obviously the infrastructure, and another is regard to the search. So all these three are subsumed into one. That is a Khelo India program. It's a broader program. Rest of the things, everything that whatever you think of required for the sports development, infrastructure, training, finances, scholarship, search of people, everything is there here. And there is one of the objective of this program is just last line to win them away from the unproductive and disruptive activities and mainstream them into the nation building process. So this might be one of the objective which will be given. So most of the times we don't think that this might be the objective. Okay, that to win away, what is the reference here? Which are these people? Naxalite, okay, or any other people who are diverted from the mainstream. And so that's also the one of the objective, broader objective include here. Silent features of the program is nothing. Just one of the thing is 100,000 most talented young athletes each year to be selected, 1,000 people. And each athlete, this is a significant one, each athlete selected under the scheme will receive the annual scholarship of 5 lakh rupees for 8 consecutive years. So 5 into 8, 40 lakhs. Okay. So UPSC or Khelo India, देखिए क्या है? ठीक है. There's something which is coming, Loco, or you guys are playing that? Loco, some app is coming. Okay. Some trivial questions they are asking. National Sports Talent Search. Okay, that is it. Khelo India. Next is Target Olympic Podium. The short form of it is top karo. Okay, so that is a Target Olympic Podium. This is Khelo India is in general for the sports. This is particularly to increase the performance in the Olympic. Okay, so that is it. That is to identify and support the potential medal prospect for the 2016 and 20 Olympics. And the benchmark for selection of these athletes will be as per the international athlete standards. So this is top, that is Target Olympic Podium, and Khelo Abhiyan is in general. Next is the E-Samiksha. Samiksha is, what is Samiksha? What is the meaning of Samiksha? English? Review, inspect. So obviously the central government department have been asked to work out specific target to be achieved by 2022, which will be monitored by the PM under the E-Samiksha program. Samiksha is reviewing. So the same thing, online tracking, real-time basis, minimum government, maximum government, so all those common cliche things of digital India, transparency, accountability, real-time. Just remember that E-Samiksha platform is Samiksha of government targets. Public finance management system. Government has made the use of to monitor all the sector schemes. That's just again the same thing, just one of the platform through which they are going to see the functioning of finances. Web-based software. Just remember this comes under the Controller General of the Accounts. This is a web-based software application developed and implemented by Office of Controller of General of Accounts, CGA, for all the programs. Next is Mission Antyodaya. This is important. Mission Antyodaya. What is Mission Antyodaya? Without seeing, can anybody tell me? Just one line of it. Mission Antyodaya. Poverty, removing poverty. So there are 50 schemes for removing of poverty. Okay, that was during the time of UPA. These days it is a Din Dayal Upadhyay. NRLM, have you heard of it? What is NRLM? National Rural Livelihood Program. Is it a wage employment or the self-employment? Self-employment. It is a skilled or unskilled? Yeah, they are going to skill the people. Okay, it is not unskilled. See, unskilled wage is Narega. Okay, unskilled wage is Narega. And skilled self is NRLM, which was actually the Swarozgar Yojana, initial name was. So it becomes a NRLM, National Rural Livelihood Mission. And now it becomes Deen Dayal Upadhyay National Rural Livelihood Mission. So in that, there will be self-help groups, etc., etc. Lot many activities in order to impart the skill to the people. Now, when you are imparting skill and employment, the opposite side of it is you are elevating or ameliorating the poverty. Okay, so they're the two sides of the same thing. One is it's an employment generation program also. On the other side, it is a poverty elevation program also. So the mission Antyodaya was actually nothing but a part of this Deen Dayal Upadhyay NRLM. In that, whatever the initiative that we are going to take in NRLM will be at the grassroots, at the panchayat level. So they have identified these clusters of panchayat. There is a box, and in that box, the last line, if you can refer, mission aims to transform 500 rural clusters or 50,000 gram panchayat. This is the objective of, if you want to remember the statistics of Mission Antyodaya. So statistics of Mission Antyodaya are 50,000 gram panchayat and 1 crore of although that word is not mentioned, 1 crore of households. 1 crore of households from the 50,000 gram panchayat will be given the livelihood thing. That is about the objective of Mission Antyodaya. Now, in order to implement this, they are obviously lot many operations are required at the grassroots level. So, in the box, that pictorial box, you can refer what is the Mission Antyodaya. So, there are issues with regard to convergence of different schemes. That's the most important thing. There is convergence and saturation. Saturation means region and need specific approach. What is required in which area. So it's a saturation approach, third point. And overall it is called convergence and saturation. Convergence means convergence of different schemes. And saturation means saturation at one particular area so as to focus the needy and the region specific people. Second is focus on raising the income through the different activities and imparting the skills as well as giving the micro credits through the self-help groups. Third is institutional strengthening. Again, this credit providing institutions that will be strengthened. And the last is integrated monitoring dashboard. What is the progress of all these things? So this is a mission Antyodaya, which is actually at the level of panchayat in order to for the poverty alleviation and by providing the gainful employment. So these are all the parts of, and they are going to collect the data obviously from the schedule, this SCCC, socio-economic caste census, into it targeting, etc., etc. So all different key processes in the convergence, etc. Whatever you can think of, all the organizations, NGOs, institutions which are there working at the grassroots, they are trying to bring the convergence and the synergy between them. So the overall name is Mission Antyodaya. That's it. Initiative for the Northeast. See, there are list of the things which are given. I don't think so. They are very, very important. Just I'm reading the title name. Niti Forum for Northeast. So Niti Aayog ka ek separate forum hai. That is for the Northeast. Just remember the vice chairman. It will be co-chaired by the vice chairman of Niti Aayog and the Ministry of Development of the Northeast. That's the one important thing. Co-chair. That is the vice chairman and minister. Rest of the things are not important. Northeast Rural Livelihood Project, again, this is externally aided program. World Bank is assisting in particularly 4 different states. Again, not so important, I don't think so. Okay, that's a very specific. Yes, the third one is important, I think. The Northeast Calling Festival. So there are 2 things here, 2 keywords. One is Destination Northeast and the Northeast Calling. So Destination Northeast is a broader program where they are, if you can refer to the first blocks, Destination Northeast. This is an event through which it will promote the Northeast region through the business summit, tourism, skills, startup, handloom, etc., etc. So lot many other things are included into it. So in order to promote, it is an attractive destination for the investment. So they are going to conduct the business summit, tourism, skill development, whatever required for the economic growth. That is called Destination Northeast. The second is Northeast Calling. Northeast Calling is particularly the cultural programs, okay, in order to increase this. So this is a festival of event which will have the art, culture, heritage, cuisines, handicrafts, business, tourism of the Northeast. So they are intrinsically linked, but this festival has organized by the Ministry of Development's Destination Northeast. So Destination Northeast is a bigger program. Within that, there is a Northeast Calling. Okay, so calling is you go to the Northeast, visit, etc., etc. Okay. Next is Northeast Spatial Infrastructure Development Program, not required. Leave that. Non-lapsable. These are all old programs. Just they have been categorized into one. All these three are very, very old. 2007, 10, and etc. Not that important. Come to the Umang app. What is Umang in English? Tarang. Rejoice. Okay. Tarang is? There's Tarang app also. Tarang app is for what? Power sector, yes. Umang, Unified Mobile Application for New Age Governance. Okay. See, this is basically the G2C platform, government to citizen platform. So whatever the services that are being hosted by the government, okay, they should be seamlessly accessible to the common man. So that is the platform Umang app, one single app which can give the access to the online government services. That's it. That is Umang. Rejoice. You can rejoice that I can get all the government services on the single standalone platform. The most important one was the Aadhaar. Okay, they have said multi-utility app integrates. I hope it will not collect the data and send somewhere. Aadhaar, DigiLocker, Rapid Assessment System, Bharat Bill Payment, supports 13 Indian languages. Okay, so that's the part, Umang. Next is GEM, Government Marketplace. See the GEM, this basically government procures lot many things. Government sector, there is a central government as well as the state government. They needs to procure lot many things to run the programs. So in order to procure the programs, they requires a real-time data of prices, ratings, and everything, quality, material, etc., etc. So in order to facilitate this process of procurement by the government and to get the real-time data of the quality and the prices and the rating of the products, so they have developed this web portal, that is Government E-Marketplace. Okay, e-marketplace. So there will be a data that will be available. So just read that the box. The government e-marketplace initially launched in 2016 online market platform to facilitate the procurement of the goods and services by the various ministries and agencies. Okay, and this is being hosted by National Procurement Portal of India. It is under the PMO. That's it. Nothing much is there. Next, how many pages are remaining? 2. Okay. International comparison program. This is obviously international comparison. There are a lot many indices. One of the indices is this international comparison program. This is by the United Nations Statistical Commission and being initiated by World Bank. So that's, I was saying, some of the indices and the reports and who host and who comes up with that, you just have to remember. So it was initiated by World Bank and under the auspices of the United Nations Statistical Commission. Nothing much, there will be a ranking, that's it. So International Comparison Program. Next is National Register of Citizen. Just tell me without seeing it, what is this and is it compulsory? How it is different from the Aadhaar or enrollment? What is National Register of Citizen? Yes, anybody? Yes. Yes. And why it is all the more significant? Yes, in case of Assam. So let's see that, see the thing is, this is obviously the register of the citizens. Now the point is, this was in the context of, if you see this illegal migrants coming to the northeast, particularly to Assam. So there was a Assam Accord which was signed, the then Prime Minister Rajiv Gandhi and this ASU, Students Union. So the Assam Accord says that till this date, 24th of March 1971, whoever people are already migrated, so they will be the part of India, and there will be a statistical data. Okay, but the promise was made that after 24th of March 1971, whoever will come or has entered, they will be considered illegal. So if you are entrant into this data, then obviously you are the legal one. Otherwise, you will have the illegal status. So that's why that data was important, and it was a part of Assam Accord. So this process now has been completed. State of Assam has published the first draft of updated National Register of Citizens. Okay, so the Assam has published it. NRC contains the name of bona fide Indian citizens of Assam that distinguish them from the foreigners. So if your name appears, you become Indian, otherwise you are a foreigner or illegal migrant. The NRC is now being updated time-bound manner to incorporate the Assam Accord of 1984 in order to tackle the issue of illegal migration from the Bangladesh, in order to distinguish the people. But obviously there were a lot many controversies with regard to updation only, because those people who came and entered, they because they were fearful that they will be considered illegal migrants and they will be sent back or deported back. So they got all this Aadhaar, the then Aadhaar, matlab kya tha, dekhiye, matlab voting card and driving license and everything. And those who were the residents of Assam, they say that we are already the son of soil, so who will touch us? Eventually, when the upgradation started, so when you will be asked, so you becomes the illegal migrant because you don't have the document. So ultimately, it boils down to what is legal is whether you have a document or not. No, it is not regular. That's what he has added, that it has been updated by the Assam for the first time. It was there in initially 1951. So the last line we'll read. The NRC will include the names of the person of their descendants whose name appear in the NRC 1951 or any of the electoral rolls up to the midnight of 24th March 1971. It means that there was a data. 1951 is data, and then this date is with regard to the Assam population of Assam, 24th March. So yes, everybody is required, but there are certain duplication work that we are seeing because of why I started with saying that what is the difference between Aadhaar and this National Register of Citizen. But what is the difference? Who gets the Aadhaar? Aadhaar get by only Indians? What is the? Resident of India. The word is resident of India. So Aadhaar is just you are a unique person. Beyond that, it does not speak about anything, that what is your identity. It only says that whatever the name is, you are the identified, biometrically identified person. So therefore, this has its own significance, they say, because they are talking about Indian citizens, whereas Aadhaar is for the Indian residents. Anyway, so this was the point you should remember. In Section 6A of Citizen Act, which I already mentioned, those who are traveled before March 24th, 1971, they will be the part of India and rest of are not. That is a part of Assam Accord. Next is Indian Exclusion Report. Exclusion is obviously where there is no equality. So Center of Equity Studies are providing this report, and they will going to include pension for elderly, digital access. So what are all the exclusions? And they will collect the data and publish the ranking. Okay, nothing much there again. Just remember this Indian Exclusion Report is by the Center of Equity Studies. UN and Punjab are collaboration on the drug menace. That is UNODC, that is United Nations Office of Drugs and Crimes. Udta Punjab, okay, so yes. Nothing much here. The strategy to combat drug abuse, it is a main answer actually. Prevention, law enforcement, and the rehabilitation. These are the three umbrella approach of drug control crime. Prevention, law enforcement, and the rehabilitation. Global index for the countries. Global index, that is OECD has, yes, OECD government has a glance report. State, 73rd% of the Indians have the tremendous faith in the government, which is the third highest in the world. That is a good news. I don't know where they have collected the data from, but it's quite encouraging that we are the third, okay, where we have the tremendous trust in the government. The first one is Switzerland. Oh, I think we are so close to Switzerland. Okay, anyways, so that's good news for Indians. OECD. OECD countries have published this report, and in that, India stood third, okay, having the faith and the trust in the governance. Some of the trivia of the OECD that there are 34 countries, 1960. Just remember the last two things because these are important. OECD maintains the blacklist of the nations that are considered uncooperative tax havens. So that's very significant when FATF and all those things. So OECD is very, very prominent in that. Panama, Mauritius, all these countries. It publishes the economic outlook, the report. Okay, so OECD related these 2-3 things, blacklisting of nation economic. The last one is merger of NCRB with PBRB, that is National Crime Control Bureau with the Bureau. Nothing merger is there. Anything left? I think we are done finally. Okay, so I'll leave you with the email ID if you have any doubts or anything you want to ask. So you can. See, the thing is, okay, student query. Can this section be needed to the question in the existence of the religion and the caste-based policy? Okay, this is an important question I will just discuss. Okay, the question was like, there is a section 123 of Representation of Peoples Act, 1955. Can these sections be used to question the existence of religion and the caste-based politics? Yes, what is section? There is a development also last year on section 123 of Representation of Peoples Act. Anybody knows what is this section? This section prohibits, yes, caste, religion, language, or any other this parochial criteria as race. Okay, religion, caste, language, race, in order to influence the voters. Okay, they neither can ask to vote against or in favor based upon these criterias. Okay. Now, this act is already there. This section was already there that any person, any political person or candidate, political candidate, and people related to him, his agent, and etc., etc. So, if they get involved into the influencing the voter based upon the religion, caste, race, so obviously it will be considered as electoral offense. Okay, so this is there. So the question is being asked is, can this section be used to question the existence of religion and the caste-based politics? Yes, certainly, because when you are mobilizing the people on the basis of religion and the caste, so it will be considered as electoral offense. Now this was already in the news, and many of the, I have seen in the market many these articles, okay, wrongly put it. Now, this is a landmark decision that race and religion and the caste will no more be the criteria for influencing the voters. Now, what is the Supreme Court decision in this? This is already existing since till eternity. So, what was the decision? Yes, so actually this provision was already there. It was just the word his was interpreted. Okay. Now, what was, yes, anybody knows what is this, his word was related, what was the interpretation here? See, this is the candidate and his agent and his people who are influencing. So, his people so whether he and his appointees will be the part of him or not, that was the only question which was there. So, it is, so initially it was thought that his is only the population. Are you understanding? The voter to whom the candidate is addressing to. Say, for example, I am a leader and you are my prospective voters. Okay. So, when I am inciting through the religion and caste and race, so this his is related with his means your religion. So it means that if you belong to X religion and I am belong to Y religion, I have every reasons to say that Y religion is really good and this and that and etc. So they will say that you are inciting the violence. But I will say that no, his population was related only with, I have not taken your religion name. But then interpretation was his was not related to the voter only. His is also related to me and my this thing. That was a very, very technical interpretation which came that no, it is not related with the voter or the population. It is also related to his own religion and the agent that he is appointing in order to influence the voters. Have you understood? So that's a section which is considered as electoral offense. Can smaller benches overrule the decision of higher benches? Is a little technical. Anybody from the law background? Yes. What is this? We have already discussed, but smaller benches overruling the decision of higher benches. We follow the policy of. Okay. Higher. Yes. Lower bench. Yes. Higher bench. Yes. Yes. I think that's the point which we were discussing, that if Keshwananda Bharati, the basic structure is given, so basic structure cannot be taken down by the 2 bench, 3 bench, 5 bench. It has to be 14 bench or say 15 bench and then only it will be overruled. So that's the thing. Yes, anyways, I'm leaving you with this email, and if you have any issue, so you can mail or get. Gmail. So any query, anything, you can just get back to this. And all the best. Okay. Yes. Just one thing. I have done this thing, but the thing is, I believe that you focus more your current affairs on the rest of the other areas, particularly the economic part and this environment and the schemes. Okay, those are the important one. Generally, the use of this discussion was to highlight those areas within the Lakshmikant, which are the most likely to be asked. But it is nothing like that, only these areas are important, rest of the areas are not. Rest of the areas are also important, but doing this exercise help in not leaving those areas which you might ignore to be less important. That's the only thing, okay? So all the best, okay? And write well, okay? Thank you so much.